Vice Chair Finlev, we're ready to begin.
Good morning, folks. Welcome to the February 9th, 2024 regular meeting of the San Francisco Ethics Commission. Today's meeting is live cablecast on SF.gov TV2 and live streamed online at sfgov.tv/ethics live. For public comment, members of the public may attend in person or may participate by phone or on the WebEx platform, as explained in our agenda document. Clerk, can you explain how remote public comment will work?
Public comment will be available on each item on this agenda. Each member of the public will be allowed 3 minutes to speak. For those attending in person, opportunities to speak during the public comment period will be made available here in room 400, City Hall. For those attending remotely, public comment can also be provided via phone call by calling 1-415-655-0001. Access code is 2664-368-0498, followed by a pound sign, and then press pound again to join as an attendee. When your item of interest comes up, press *3 to raise your hand to be added to the public comment line. Public comment is also available via the WebEx client application. Use the WebEx link on the agenda to connect and press the raise hand button to be added to the public comment line. For detailed instructions about how to interact with the telephone system or WebEx client, please refer to the public comment section of the agenda document for this meeting. Public comment may also be submitted in writing and will be shared with the Commission after this meeting has concluded and will be included as part of the official meeting file. Written comments should be sent to ethics.commission@sfgov.org. Members of the public who attend Commission meetings, including remote attendance, are also expected to behave responsibly and respectfully. During public comment, please address your comments to the Commission as a whole and not to individual members. Persons who engage in name-calling, shouting, interruptions, or other distracting behavior may be excluded from participation.
Thank you, Mr. Clerk. I now call the meeting to order. Mr. Clerk, will you call the roll, please?
Commissioners, please verbally indicate your presence by saying aye after your name is called. Vice Chair Finlev?
Aye.
Commissioner Flores-Fang?
Aye.
Commissioner Salahi?
Aye.
Commissioner Tsai?
Aye.
Commissioner Francois?
Aye.
Vice Chair Finlev, with 5 members present and accounted for, you have a quorum.
Thank you, Mr. Clerk. I want to welcome our newest commissioner, Commissioner Francois. Would you like to say a few words to your colleagues and the public?
It's an honor to be appointed by Mayor Bree to be a participant on this commission, and I look forward to working with you and the citizens of San Francisco.
Thank you. Welcome. With that, I call agenda item 2, general public comment. Are there any speakers in the room who would like to make public comment?
Yes.
Go ahead.
With my name tag, so you will not spell my name wrong. Good morning, Ethics Commissioners. My name is Ellen Lee Zhao, ELLENLEEZHOU. I pledge the allegiance to the flag of the United States of America and to the republic which it stands, one nation under God, indivisible, with liberty and justice for all, born and unborn, vaccinated and unvaccinated workers. In Jesus' name, amen. I was a public health worker for public health for more than 15 years. I am a union delegate for all government employees in San Francisco. I have been working and living in San Francisco for 38 years. I was nominated to run for mayor in 2018 and 2019 against tyranny. Ethics Commission Department has been discriminating against me and retaliating against me after I exposed corruption within different departments in San Francisco. Take note, I am not surrendering to evil. I am not afraid of any one of you, nor Satan, nor Lucifer, nor demonic leaders in the government. Take note, 2024 this year, I am running for San Francisco mayor again. I believe God of Abraham, Jacob, and Isaac will revive San Francisco if you and me, we all repent, turn from the wicked ways and humble ourselves. God will heal our land, San Francisco. I don't give up my city. I believe God save us when we stop murdering little people. Protect our children. Let God arise in San Francisco. I have been coming to Ethics Commission public hearings with many government employees in different days, 2016, 2017, 2018, 2019, 2020, 2021, and 2023. The last time I was speaking to you, this Ethics Commission, was in December 8, 2023, which I spoke out against San Francisco Ethics Commissioners and unethical staff and unlawful investigation against conservative candidates like me who do not agree with evil policies that fail to protect our children, our family, our workers, and the people's interests. Today, I'm here to ask you to end your unethical, illegal investigation against any conservatives do not accept Agenda 21, Agenda 2030, nor agree with your tyranny policy that failed to deliver a quality of life for San Franciscans. Save San Francisco from God's judgment. I urge all of you to repent, turn from your wicked ways, and return to righteousness. Return to law and order, and may God bless you all, and come back to God's kingdom. Come back to Jesus. Amen. Thank you.
Thank you. Any other public comment from the room? Mr. Clerk, will you check if there are any remote public commenters?
Vice Chair, we're checking to see if there are
Pagers.
any callers in the queue. Vice Chair, there are no callers in the queue.
Thank you. Hearing no further comment, hearing that no further members of the public wish to speak, general public under item 2 is closed. I now call the consent calendar. Colleagues, as noted on the agenda, there will be no separate discussion on a consent calendar item unless a request is made by a commission member or member of the public in attendance, in which event the matter shall be removed and considered as a separate item. Do any commissioners wish to discuss any of the items on the consent calendar?
Just like to pull number 4, Executive Director's Report, please.
Thank you. And I actually have a very quick question on the enforcement matter, which is number 5. So I move to adopt number 3, the draft minutes. Is there a second?
Seconded.
Mr. Clerk, would you call the roll on the motion to adopt item number 3 on the consent calendar, the draft minutes?
On the motion to adopt item number 3 on the consent calendar, draft minutes, Vice Chair Fenliv,
Aye.
Commissioner Flores-Fang,
Aye.
Commissioner Salahi,
Aye.
Commissioner Sai,
Aye.
Commissioner Francois.
Aye.
Vice Chair with 5 votes in the affirmative. The motion is approved unanimously.
Thank you, Mr. Clerk. For the item number 4, Mr. Ford, that's probably comes to you.
Good morning, Executive Director Ford. It's nice
Morning.
to have you here. I know there wasn't much time between your appointment to this position and this report, but I just wanted to flag that I think there was at some point a discussion about putting updates about the status of the audit program on this meeting's agenda. Has that been postponed to a future?
So I can give you some high-level updates right now, and we can bring back more information. So the most recent update that we've gotten from the contractor is that they're looking to have all of their draft reports to us by the 1st of April. So if that target is met, then our audit staff can do the steps that they need to do to finalize them, which involves interacting with the committees, reviewing them, obviously, and then getting them approved by me, and then posting them. So we're shooting to do that by the end of the fiscal year, so end of June. We want to have all of the 2022 and 2020 audits final and posted.
Thank you. That's really good news. Thank you.
Any other questions from my colleagues? No, Ms. Flores will correct me, but I think we have to do public comment on this because we considered it. Is that, even though there's no action on it? Is that right?
I think in an abundance of caution,
Yes, in an abundance of caution, we should just do public comment.
Would any of our participants in the room like to make public comment on this item only? That's the Executive Director's report. Please go ahead.
Good morning again. My name is Ellen Lee Zhao, ELLENLEEZHOU. I'm here to remind you, whatever the business you do in here and Ethics Commission, because you said they're new and not ready, whether ready or not. So if you receive a paycheck then you should be 100% ready for your work. Whether you volunteer, because you volunteer, you still get stipend. This is a public hearing. If you're not ready to serve a role as ethics commissioners or work as an ethics commission staff, please don't come to work. I have been dealing with ethics commission staff. Many of my questions were able to answer, and some of them not able to answer. The question is, well, I'm new in here. Well, I don't know this question. And then sometimes they don't get back to me. And when something goes on, they'll say, well, you didn't comply. So I'm here to remind you, if you sign up to do what you do, and you're not ready, just don't show up. And if you are sitting in there, then you should know the policy, the public policy, the Brown Act, and the Sunshine Ordinance, codes and regulations. And those codes and regulations apply to paid government employees, paid appointees, but not apply to the people like me right now in front of you. The people, we the people, do not comply to your rules and regulations because those are for you, the people who get paid, you, the people get appointed. So I'm just reminding you, be the best you can be, work the best you can be, and if you're not ready, don't come to work, and don't come to this ethics commission chambers. Thank you, and God bless you.
Mr. Clerk, would you check if there are any remote callers?
Vice Chair, we're checking to see if there are remote callers in the queue. Vice Chair, there are no callers in the queue.
Seeing none, item 4 is closed. Again, that was no action on that part. That was for information only. On agenda item 5, that's the proposed stipulation. I just had a very quick question to staff. Looking at Exhibit A, the second paragraph describes the violations, and I know that the fact pattern are that the organization solicited contributions from its own members and then failed to register as a committee. The mere fact that the contributions were from its own members is beside the point, right? It's the failing to register that's the issue.
Correct,
No.
yeah. And it's the soliciting contributions for the purpose of using them for political activity. That's a required sort of meeting of the minds requirement under law to turn a multi-purpose organization into a required political committee.
Right, but there's nothing inherently problematic with soliciting its own members, is my understanding.
Correct, yeah.
That's great. I just wanted to confirm that. That was all the questions I had. I move to, well, sorry, I should see if any of my colleagues have questions on this matter.
None for me, thank you.
Seeing none, I will move to accept staff's recommendation and us to agenda item 5, accept the proposed stipulation. And then I think before we take the roll, we'll take public comment on this item. Does anyone in the audience wish to speak on this item in particular? Again, limited to agenda item number 5. Seeing none, Mr. Clerk, would you check if any of the remote callers would like to comment on this item?
Vice Chair, we're checking to see if there are callers in the queue.
Thank you.
Vice Chair, there are no callers.
Thank you, Mr. Clerk. Would you take the roll, please?
On the motion to adopt the consent calendar, Vice Chair Finlev?
Just for clarity,
Oh,
this is a
sorry.
motion to adopt item number 5.
Sorry. On the motion to adopt item number 5 on the consent calendar.
Aye.
Commissioner Flores-Fang?
Aye.
Commissioner Salahi?
Aye.
Commissioner Sai?
Aye.
Commissioner Francois?
Aye.
Vice Chair, with 5 votes in the affirmative and 0 votes opposed, the motion is approved unanimously.
Thank you, Mr. Clerk. That brings us to item number 6. Mr. Ford, do you want to explain how this may go?
Thank you, Vice Chair Finlev. Again, for the record, Executive Director Patrick Ford. The Commission's bylaws do not provide for a specific method for the election of its officers. The Commission has customarily employed the following procedure for the election of its officers. The Chair will open nominations for Chair. Any Commissioner who wishes to nominate a candidate for Chair will state the name of that person. If that person agrees to run, that person is nominated. Commissioners may also self-nominate for Chair. When there are no further nominations, and following any public comment, the Chair will close the nominations and take a roll call vote in which each Commissioner shall state the name of the nominee for whom he or she is voting. If a nominee receives 3 or more votes, that person is elected Chair for a 1-year term of office beginning March 1st. If no nominee receives 3 votes, the Commission may have further discussion and proceed to another vote. This process shall repeat until one nominee has received 3 or more votes. Following action to elect a chair, the chair will then open nominations for vice chair. Any commissioner who wishes to nominate a candidate for vice chair will similarly state the name of that person. If that person agrees to run, that person is nominated. Commissioners may also self-nominate for vice chair. When there are no further nominations and after public comment, the chair will close the nominations and take a roll call vote. If a nominee receives 3 or more votes, that person is elected vice chair. It's essentially the same process as electing the chair.
Thank you, Mr. Ford. And Ms. Flores, I believe I can just take public comment now, once for the entire item, right?
Yes, public comment should come at any point before you make a final decision. So you can take public comment now or after you deliberate, but
Thank you,
before a final decision is made.
Thank you. We're ready for public comment. It looks like we have a person. Please go
Well,
ahead.
good morning again, commissioners. My name is Ellen Li Zhao, E-L-L-E-N, L-E-E-Z-H-O-U. As you nominate the chair for commissioners, I am here to remind you, whoever the chair that you nominated, and all of you, is the same position that you are liable personally for anything that you are not comply to the law and order, not necessarily code and regulation. Code and regulation is for the paid people and the appointed people, but not for the people of the public interest. December 8, I was here and speak against whoever will be hired as a chair. And if you hire this person and you pay this person, I will file another lawsuit to sue. At the commission, I am here to give you the public notice. And the reason, 2022, April, to the end of 2022, there are 1,168 public employees who are Christians and Catholics who file religious exemption, did not accept the COVID-19. Now we know it's a bioweapon. All people turn in the exemption paper were wrongfully terminated. As of today, we have 11 federal lawsuits, 6 state lawsuits against San Francisco mayor, against different department leaders, and against Ethics Commission soon if you continue to file this process to hire a person, but you are not reappointed, reinstate all the wrongfully terminated, unvaccinated workers, and I am one of them. The law says anyone receive a medical procedure, anything related to medical, you have to have public consent, which is the patient's consent. But San Francisco in 2020, 2021, 2022, 2023, and today, still putting ads out there, vaccinate yourself, protect the people, protect the public, protect the seniors, vaccinate yourself. I'm telling you right now, congratulations to all of you. Today, I didn't see any masked people here. You people have common sense. Thank God for you all. The last Civil Services Commission I was in last Monday, 4 days ago, they get N95, mask, vaccinated. I'm not against masks. I'm not against vaccinated. But if you hire a new employee, but reinstate all the wrongfully terminated 1,168 Christians and Catholics, that is a lawsuit for discrimination. Thank you.
Thank you. Would any other members of the public like to make public comment present here in person? Seeing none, Mr. Clerk, would you check if there are any folks on the WebEx who would like to make comment?
Vice Chair, there are no callers in the queue.
Thank you. I'll now open the floor for discussion and nominations.
I'd like to nominate Commissioner Finlev for the position of chair.
I accept. Are there any other nominations for chair? Well, actually, I guess we will. Ms. Flores, you'll have to help me. Do we vote now, or do we then take other nominations first?
You vote now for chair if there are no other nominations. I can do the roll call vote for that.
Do we have to second
We
that
need a
motion?
second?
Yeah, I'll second
we're
it.
gonna-
Yeah.
Thank you.
Should we say aye now, or?
Oh, I can do a roll call for you. That way you don't have to do it. Vice Chair Finlev?
Aye.
Okay. I think you're supposed to state the name of the person, I think.
I support Vice Chair Finlev for chair.
Commissioner Flores-Fang?
I support Vice Chair Finlev for chair.
Commissioner Salahi?
I support Vice Chair Finlev for chair.
Commissioner Sai?
I support Vice Chair Finlev for chair.
And Commissioner Francois?
I support the vice chair. I'm sorry can't pronounce your name.
That's okay.
Vice Chair Finlev, by a vote of 5-0, the Commission has elected you as the chair for a term beginning March 1st, 2024. Congratulations.
Thank you. And now I will open up for nominations for vice chair. I would like to nominate Commissioner Flores-Fang for vice chair.
I second that.
I accept.
Would you call roll, please?
Yes. Chair Finlev?
I support Commissioner Flores-Fang for vice chair.
Commissioner Flores-Fang?
I support myself for vice chair.
Commissioner Salahi?
I support Commissioner Flores-Fang for vice chair.
Commissioner Sai?
I support Commissioner Flores-Fang for vice chair.
And Commissioner Francois?
I support Commissioner Flores-Fang for vice chair.
By unanimous vote, Commissioner Flores-Fang, you are elected vice chair. Congratulations.
Thank you, Mr. Ford. I'll just briefly say I see one of my main responsibilities as chair as running efficient meetings. So that's going to be my priority, in addition to all the other work we'll be doing together. I now call agenda item 7, discussion and possible action regarding the hearing on the merits in the matter of Paul Allen Taylor. I think we need to take a small pause for
Yes.
Deputy City Attorney to make some arrangements. Should we take a 5-minute break? Mr. Ford, can we take a 5-minute pause?
Certainly can.
I now call agenda item 7, discussion and possible action regarding hearing on the merits in the matter of Paul Allen Taylor, case number 20-243, 1920-031. Will representatives of each of the parties please introduce themselves, starting with ethics staff?
My name is Zachary D'Amico. I'm speaking on behalf of the Enforcement Division.
Mr. D'Amico, is there anyone here on behalf of Mr. Taylor? Seeing nobody? Sir, are you Mr. Taylor?
Taylor's going to make some comments.
Great, wonderful. We're happy to have you here. Please hold on one second, but there will be an opportunity for you, sir. I'm glad you're here. Thank you. We'll start by calling for public comment on this item. Is there anyone in the room who would like to make public comment on this item? And Mr. Taylor, you'll have a chance to speak. This is just for public comment. Seeing no.
Well, good morning again. My name is Ellen Li Zhao, ELLENLEEZHOU. For some reason, I feel very honored that my name is keep mentioned in this Ethics Commission. I have to give you a thumbs up. 2019, I ran for mayor. That's 2019, people. Right now it's 2024. 5 years later, this Ethics Commission, the most unethical department, continue to go after conservatives who love God, who love life, who oppose killing little human beings, who do not support mutilating children from boy to girl, from girl to boy. You have the guts, keep going after a person in front of you right now, Ellen Li Zhao. I have been working as a behavioral health clinician for public health for more than 15 years. I provide treatment for delinquent youth who are selling drugs, who are truancy, who are depressed, who are anxious. I also work with adults who are depressed, suicidal, homicidal, just got out of jail. I work with people homeless, dying on the street. I witness bodies, dead bodies in front of me. I know the numbers, how much the government corrupted. So I spoke out the truth. I came to Ethics Commission for the last minimum 6 years with many, many government employees against tyranny, against many department heads, that they are paid and barred into positions. They rape Chinese women. They rape people in order for them to get a job. How do I know? I was working with the FBI to investigate those leaders. That was why the people came to me and nominated me to run for mayor in 2018 and 2019. I knew the number, I knew the people, but I'm not at liberty to say it here, because that's the law. But I urge you today, it's time for you to stop. Rise up and work together, save the homeless, save the dying people on the street. Catch up those thieves in the store and take care of the city like I do, like I have been doing. I have been living and working here for more than 38 years. I love San Francisco. I love you all in here. So stop your tyranny against a person like me.
Thank you, Speaker.
Thank
Your
you.
time is up.
Thank you. Would anyone else like to make public comment here in the room? Mr. Clerk, would you check if there are any remote callers?
Vice Chair, there are no callers.
Thank you, Mr. Clerk. Public comment is closed. Colleagues, there are a couple of preliminary matters that I want to discuss before we start. I was appointed as a pre-hearing commissioner previously, and I issued an order, but we never discussed how we will run the actual proceeding itself. We're going to preside as a body all together, but I think we need someone just to MC it at a minimum. I'm happy to do that as being familiar with the matter, but I think to the extent we have any evidentiary questions or anything like that, my idea would be to all discuss it together and address that jointly. My understanding is that within 45 days of a hearing closing, we have to basically not make findings, but vote on the allegations, especially given we have a new member. My proposal would be that we don't do that today necessarily. We can discuss this after the hearing, but we have an opportunity to do that at the subsequent meeting, and we can designate one of us to propose findings in the meantime and then submit them for the next meeting and vote on them at that time. But that's just my approach. I'm happy to hear the thoughts. The other idea is to try to have a vote today after the hearing, and I would welcome if staff or Mr. Taylor have thoughts on the process. But that's how I see it, and I just want to discuss that in advance so we're on the same page. So if there are any thoughts from my colleagues, I'm happy to hear them in terms of just the mechanics of how we move forward today. And I should say that all of our deliberations are going to be in public, so there's no kind of separate closed deliberation process.
You have a procedural question. So you're saying your understanding is that we don't need to vote on findings within 45 days of the hearing?
Sorry, we do within 45 days. So it doesn't have to be today, but it would have to be within 45 days of today, if the hearing concludes today.
Got it.
That's my understanding.
And I'd just like to clarify that today we'd be receiving all the evidence, or we'd be seeing all the evidence. So it's not like if we waited until the next meeting, there would be additional evidence to consider in the interim. Is that correct?
That's my understanding. The evidence would close today, and then we would have 45 days to make our findings.
But we would have to vote on those findings within 45 days, so they would be presented at the next hearing and voted upon.
Yeah, it'd be kind of at the same time where someone would circulate proposed findings, and then we would discuss them at the subsequent meeting, make any amendments that the body sees fit at the meeting, and then vote on them then, as opposed to trying to do that all today.
Understood.
And we can revisit that after the hearing today, but I just wanted to kind of make sure that's something that we're thinking about. Does that make sense for everyone?
Yeah, that's helpful. I'd just like to flag that if we wouldn't if we didn't vote by the next meeting, the 45 days, 45 days from now is like the end of March. And so
Right.
we have to vote.
That's right, yeah. So I'm going to ask the staff and Mr. Taylor if they have any comments just on the mechanics. You're going to have a chance to talk about the actual merits, but I just want to hear from staff and Mr. Taylor if they have any, if they read the rules differently than what I've outlined.
No, that works for us.
Mr. Taylor, and again, you'll have a chance to talk on the actual allegations, but purely on the mechanics that we've discussed today. Okay. Great. In that case, we will now proceed. So here's the summary of procedures, and this is outlined in the rules, and some of it was covered in the preliminary order that I issued. Each party may present an opening statement. The staff will go first for 15 minutes. Then Mr. Taylor will go for 15 minutes if he likes to. Each party may present a rebuttal for up to 3 minutes. And then after the rebuttals, we'll have actual evidence and testimony to the extent that there is any. Mr. D'Amico, please go ahead. And Mr. Clerk, can you keep time? Great, thank you. Yeah, great question. Commissioner Salahi asked if we can ask questions. My instinct is yes, I think we should, but it can either be now or I think at the conclusion of the evidence presented. But I think we should have the opportunity to ask questions of staff and witnesses.
Can I just ask a question? Have you then already decided before I came here that you would preside over this hearing then and make the decisions on the objections, or is that going to be the body?
I think it'll be the body. So I'm not presiding as a quote-unquote presiding officer, but I'm just kind of emceeing the mechanics.
All right, thank you.
Thank you. First, I want to note that we did bring copies of the Enforcement Division's exhibits. They're right here. We can hand them out either now or at the conclusion of opening statements and before we begin our case in chief. I already introduced myself, but my name is Zachary D'Amico. I'm representing the Enforcement Division. We also have Senior Investigator Eamon Wilson. He's on WebEx. He will be controlling our exhibits when we introduce evidence. We'll ask SF.gov TV once I ask for Mr. Wilson to show it, he will share his screen, and at that point, if SF.gov could put it on the TV, but we will obviously wait to deal with any potential objections before it gets shared. Also note for opening and closing statements, I will be here for interviewing any witnesses. I would prefer to have the witness here, and I can be sitting there to ask questions. To introduce evidence, I would also like to sit there so that the respondent has somewhere to be, which can be at the podium if he has any objections.
I think it's fine as long as the witnesses are comfortable with that arrangement.
Great. So this is primarily, of course, a case about coordination. So our plan is through evidence and witness testimony to show that the respondent, Paul Allen Taylor, coordinated between the campaign of Ellen Lee Zhao for mayor and the Asian American Freedom PAC, also known as AFPAC. We plan to show that Mr. Taylor coordinated AFPAC's $10,000 expenditure in support of the Zhao campaign, legally turning it into a prohibited contribution, causing both AFPAC and the campaign to violate contribution limits and reporting laws. The coordination was fairly simple. We plan to show that Mr. Taylor consulted for the Zhao campaign by producing a set of advertisements. He subsequently reached out to the executive director of AFPAC, introduced AFPAC to the candidate, connected AFPAC with a donor who gave them $10,000, and then provided AFPAC with the same service he provided to the campaign, producing advertisements paid for by AFPAC's expenditure. He told the AFPAC president that he would arrange all the details related to the expenditure, coordinated with a vendor, made decisions about the location and substance of advertisements on billboards, and then produced ads identical to ones previously put out by the campaign. I ask the commissioners to keep in mind that there are numerous independent ways to show coordination under city law, and the law only requires that we meet one of those ways in order to find coordination. In the process of showing this, we also plan to demonstrate that Mr. Taylor provided campaign consultant services for the Ellen Lee Zhao for Mayor campaign without registering as a consultant. And finally, we'll show that Mr. Taylor illegally withheld information in his efforts to obstruct the Ethics Commission's investigation. That also brings me to the issue of why we are here for a fairly rare hearing on the merits. In the first place, as you know, Enforcement Division staff attempts to reach stipulated settlements in nearly all matters that come through our office, which allows us to tackle both a broad and deep range of cases while maximizing fairly limited staff time and resources. In this case, the respondent, Mr. Taylor, refused to engage with commission staff for over a period of several years, ignoring document requests, failing to respond to emails and calls, rejecting the commission's jurisdiction, refusing to produce documents in response to an authorized subpoena, and ignoring attempts to engage in settlement negotiations. We believe this is an important case because of both how blatant the violation is and the respondent's failure to take responsibility through the normal stipulation process, and we hope that today the case can establish that no individual is beyond the law as enforced by this commission. That concludes my opening statement.
Thank you, Mr. D'Amico. Mr. Taylor, would you like to make an opening statement? You have 15 minutes if you'd like to. Mr. Taylor, before you start, would you just identify yourself? I know we did it earlier. Would you identify yourself for the record, please? We did it earlier, but it was your colleague kind of waved his hand on your behalf.
I, Paul Taylor.
Thank you.
Okay. This is going on the public record, correct? Recorded.
Yes, sir.
Okay, great. I, Paul Taylor, Sir Juris, the falsely accused, proceeding at common law in pro per, make this special appearance as a courtesy. And I am here as the ambassador of Jesus Christ, the living God, challenging the sufficiency of servants and the jurisdiction of this tribunal. Let me remind you that you and this commission are already in dishonor and in default with me for the amount of $110 million, which you have ignored and not paid. Yet you have the audacity to come to this forum with unclean hands, bearing false witness against me, flaunting your wicked and wanton evil motives of your hearts, proceeding as though my unalienable rights, my superior authority, and my sovereign power means nothing. How dare you? How dare you? I have no contracts with you or this commission, which binds me to your supposed jurisdiction. Neither have you produced such, yet you proceed to maliciously persecute me. You expect me from the start to respond to all your malicious demands and to obey your unlawful orders. Yet none of you ever responded to any of my documents or correspondence. Signify your utter contempt for me and your dishonor. Let me remind you, the U.S. Supreme Court has ruled that silence can only be equated with fraud when there is a legal and moral duty to speak. Yes, you have the legal and moral duty to speak and respond to me. Your silence and fraud is palpable and evidence of your malicious and criminal intent. And to this fact that no prosecutor has performed his major task by proving jurisdiction on the record as required by law, as well as a lack of verified complaint of an actual flesh and blood injury party informing me of a true nature and cause of the accusations against me, making all these proceedings a sham and a travesty of justice with no basis in the law whatsoever. And since you've denied me the due process of law every step of the way, makes you the actual criminals in this matter. And therefore, these proceedings are null and void and without force of law. let me remind you that the ninth great commandment of God, thou shalt not bear false witness against thy neighbor. As a result of your wicked and wanton behavior here, I can conclude only one thing, that this is an ungodly tribunal, is actually the synagogue of Satan, and that all of you are Pharisees here are truly your father of the devil. I also have brought documents with me that I would like to enter into the record and be given to each member of the commission.
Sir, we'll have an evidentiary portion of the hearing shortly. So would you mind holding on to those, and then you'll have a chance to...
Needs to give these to the clerk now.
Yeah, I need to give them to the clerk now, please.
Will you not be here for the rest of the hearing? Go ahead and grab them.
No objection.
Thank you, sir. Thank you, sir.
Thank you.
We're now ready for the department to present its case. Robot opening, go ahead, sure. I'll just note for the record, it appears that Mr. Taylor has left the premises. If he comes back in, I'll note that as well. Mr. D'Amico, please go ahead.
Just briefly, I'll give a rebuttal. Mr. Taylor, the respondent, has made claims of a lack of jurisdiction that mirror claims made throughout the country under what is known as the sovereign citizen theory. Courts across the country, again, I would note, have rejected this theory, the most notable being in the Seventh Circuit, where they've stated that, very simply, laws of the United States apply to all persons within its borders, and that the conspiracy and legal revisionist theories of sovereign citizens are not established law in this court or anywhere in this country's legal system. And while not wishing to give them credence, I do wish to point out that this commission does have jurisdiction. Although the respondent has left, I would just note that the California Constitution allows cities to adopt their own forms of government. San Francisco adopted their own through the city charter. The city charter grants this commission authority to enforce violations of city law relating to campaign finance, and Mr. Taylor is alleged to have violated those laws by getting involved in a San Francisco city and county election. I would also note that the commission has followed, and commission staff have followed all enforcement regulations that were issued by this commission, including related to investigations, probable cause proceedings, and hearings on the merits. Enforcement Division repeatedly expressed things similar to what I'm saying now to the respondent throughout the course of this case. We sent him copies of our laws, our guidebook, presenting our jurisdiction over this matter. That said, I'll just go ahead and stop and we can move on.
Could you please address the statement he made about sufficiency of service? Sounds like it was implicit in what you said about complying with regulations, but if you could just expressly address that.
Yes, absolutely. We served the respondent twice with subpoenas. We served a subpoena and a probable cause report to the respondent in person, and we followed up with service via mail, and we will have a witness speak to both of those instances of service.
Thank you.
Thank you, Mr. D'Amico. I think we're ready for the department to present its case. Would you call your first witness? Ma'am, can I help you? Hi. The staff will call its witness. I'm sorry, by staff I mean the Ethics Commission staff.
Should we be considering whether to move for default since the respondent has left, or since he did make an appearance, should we continue in his absence?
My preference is that you go ahead and put on your case and we move your evidence into the record. Do my colleagues feel any differently?
I'm of the same view.
Can we clarify whether anyone is here to speak on behalf of the respondent in case something comes up that might require his objection? Or
Well, that's a fair point. I don't see Mr. Taylor. Is there a representative for Mr. Taylor in the room who will be appearing on his behalf in this hearing? Seeing none, please go ahead, Mr. D'Amico.
Sorry, I'd like to start with an initial phase of evidence before calling my first witness, since we can both introduce exhibits as well as call witnesses. So commissioners, our case is split into 3 sections. Essentially, first, we plan to establish Mr. Taylor's work for the Jow for Mayor campaign, including his involvement in the production of advertisements and billboards. Next, I will call the former president of AFPAC, Mark Tsuneshi, to testify. Through his testimony and additional evidence, we plan to show that Mr. Taylor coordinated the PAC's $10,000 expenditure. Following that, I will call Acting Enforcement Director Jeffrey Zumwalt, who will speak to the respondent's failure to comply with and efforts to obstruct the investigation. Later, I'll wrap up our case in a closing statement. So I want to start with Mr. Taylor's involvement with the Jow campaign. The Jow for Mayor campaign paid Paul Allen Taylor through his company, What Engineering, to produce advertisements for the campaign. Mr. Taylor worked with an artist to produce these advertisements, worked with a vendor named Outfront Media to produce some of those ads into billboards paid for by the campaign. I will now move to introduce 5 exhibits, exhibits I, B, H, G, and D. What I plan to do is to briefly describe the relevance and source for each exhibit, pausing briefly between each and at the end for any questions or objections. If there are none, I will then ask Investigator Wilson to pull them up so I can discuss them each one by one, doing them in batches as they relate to the portions of the Enforcement Division's case.
And it looks like you printed them. Are those for us? I know that.
Those are for you, yes. I can bring them up now or we can give them to you later. Great, yeah. Yep.
While you're handing that out, I'll just remind my colleagues that as part of my pre-hearing orders, I addressed the admissibility of evidence, pardon me, and that citing the enforcement, citing the government code, the evidentiary admissibility rule is that any relevant evidence shall be admitted if it is the sort of evidence on which responsible persons are accustomed to rely in the conduct of serious affairs, regardless of the existence of any common law or statutory rule which might make improper the admission of the evidence over objection of civil actions. That's from Government Code 11513, subsection C. So I think the salient part, or part of that, is that it'll be admitted if it is the sort of evidence on which responsible persons are accustomed to rely in the conduct of serious affairs. Thank you, Mr. D'Amico.
Thank you. So just briefly, before any of the exhibits are showed, we're moving to admit exhibits I, B, H, G, and D. Exhibit I will be a copy of a California Form 460, which was filed by the Jow for Mayor campaign, which include payments made by the campaign. That was pulled from the Commission's public website by Mr. Zumwalt. Exhibit B will be a copy of a statement of information pulled by Mr. Zumwalt from the California Secretary of State's public website, showing a filing by a corporation. Exhibit H is a contract between Outfront Media and the Ellen Lee Jow for Mayor campaign, again obtained by Mr. Zumwalt. This was found as an exhibit, again listed publicly as part of a separate and unrelated civil lawsuit. Exhibit G includes 2 emails between Philip Menares, an account executive with Outfront Media, and Mr. Taylor regarding services provided to the Jow for Mayor campaign, again obtained by Mr. Zumwalt, found as an exhibit listed publicly as part of a separate and unrelated civil lawsuit. And finally, Exhibit D will be an email from Mr. Taylor to the Ethics Commission on behalf of the Jow for Mayor campaign. This was obtained from Commission staff.
Mr. D'Amico, sorry, could you please slow down just a little bit because it's taking us a moment to pull through the
Sure,
documents?
yeah. I'm going to be going through them one by one. This is just to let you know what the relevance and the source are for any objections. But yes, I will slow down.
Yeah, and I don't know if your hope is to move to submit them all together. I think it'd be easier to move to address that individually.
If I can change how I'm handling it and go one by one, and introduce the first, see if there are any objections, talk about it, and then go to the second, I can do that.
I think that'll be easier for us to manage. Yeah. Thank you.
Right. So I will start then. I'm moving to admit Exhibit I. This is a copy of a California Form 460 filed by the Jow for Mayor campaign, and it was pulled from the Commission's public website by Director Zumwalt.
I see no objection to this. Do my colleagues see anything? Based on the representation that this is pulled from the Commission's website.
Thank you.
So that is admitted.
Hearing no objections, Investigator Wilson, would you please pull up Exhibit I, page 1? And if SFGov TV, thank you. Hopefully that's visible, but can the commissioners see this exhibit either on paper or on their screens?
I can see it. Any of my commissioners not able to see it? I
Great.
think we're good.
Thank you. So as you see, Exhibit I is a copy of a California Form 460. At the top fighlighted, the statement covers the period from October 31st to December 31st, 2019. Also highlighted in the top left, the filer is the Ellen Lee Zhao for Mayor 2019 campaign. And if you look to the highlighted text in the bottom left, you can see two payments reported, both to a company called What Engineering, address on Tea Garden Street. One is for $4,520. This is for campaign literature and mailings. One is for $275 for meetings and appearances.
Where do you see that it's for literature and meetings and appearances?
The code for the $4,520 payment there's a key about a little less than a third of the way down on the page.
Got it. Thank you.
I would now like to move to admit Exhibit B, Statement of Information, pulled from the California Secretary of State's public website.
E like elephant?
B, as in brown.
And Mr. D'Amico, you said this is pulled from the California Secretary of State's website?
Yes. Hearing no objection.
Let me just
I
look
wait?
at my colleagues.
Okay.
I see no objection. Any of my colleagues?
Great.
We'll admit Exhibit B.
Investigator Wilson, please pull up Exhibit B, page 1. So here, highlighted at the top, you can see this is a statement of information for a corporation called What Engineering, Inc. Looking down to the next set of highlighted boxes, you can see that both the principal executive office and the principal business office are located at the same address on Tea Garden Street. If you look at the next set of highlighted boxes, you will see that the respondent, Paul Allen Taylor, is listed as the sole CEO and CFO, located at the same address. The secretary is located at that exact same address. Enforcement Division believes Exhibits I and B together show that the Zhao campaign for paying Mr. Taylor for services rendered, including campaign literature through his company, What Engineering. I will now move to admit Exhibit H, which is a contract between Outfront Media and the Ellen Lee Zhao for Mayor campaign. This was obtained by Mr. Zumwalt. It was listed as a public exhibit in a separate and unrelated civil lawsuit. That is, again, Exhibit H.
So this was pulled from, looks like, PACER, the Federal Electronic Docket. Is that right?
Correct.
You know what's the lawsuit about, the underlying lawsuit?
That was a lawsuit that was related to, I believe, it was a complaint made related to billboards being pulled down.
So I'll just say that the mere fact that something's on PACER doesn't necessarily make it authentic, but Mr. Taylor has had the opportunity to be here and contest any of this evidence. He's not here. I think to the extent that we have questions about what this is, it may go to the weight of it rather than the admissibility, but I would happily kind of discuss with my colleagues. What we have is facially appears to be a contract. I have no reason to think it's not, but we don't know much about it. But like I said, I think that goes more to the weight of it than its admissibility. It does appear to satisfy the evidentiary standard that I read earlier. Any comments from my colleagues?
Do you know who submitted this to in that case?
I don't know which individual, but it was submitted by the plaintiffs in that case, which are either, so that was a case that both the Ellen Lee Zhao for Mayor campaign and AFPAC brought against someone else for pulling their billboards down. And so it was some party associated with the plaintiffs, the people who put the billboards up.
In other words, it was submitted by the Ellen Lee Zhao for Mayor campaign.
Or someone affiliated with them.
Was there a representation by them that this was the purchase agreement for the advertising?
Yes.
So I think, given that, I'm happy. I think we can admit it, and any questions go to the weight, not the admissibility.
So Investigator Wilson, please pull up page 5 of Exhibit H. So highlighted at the top, you can see this is an advertiser agreement. Just below that, there's a contract number. On the left, you can see that this is an Outfront Media contract, and below that, highlighted, the advertiser bill to name is Ellen Lee Zhao for mayor. To the right, again, Ellen Zhao is listed as the advertiser, and you can see that Philip Menares is listed as the account executive.
And Mr. D'Amico, just remind us the specific relevance of this exhibit? Or if you haven't gotten there yet, then we can address that later.
So I will get to it just in a moment. So just looking below that on the left side of the middle of the page, highlighted, this is a contract for SF Bay Area posters, and on the right side, the advertising period is from October 7th to November 3rd. This contract shows will show two things. One, it will represent Mr. Taylor's involvement with the Zhao campaign on producing advertisements for billboards and coordinating those billboards. And two, these are billboards that are related to then Mr. Taylor's work for AFPAC in coordinating an expenditure.
Thank you.
If we could also show the last page of this exhibit, Investigator Wilson, please go to the final page. Here you can see a check written by the Ellen Lee Zhao for Mayor campaign to Outfront Media for $4,040, which reflects the contract. I would now like to move to introduce Exhibit G. This includes two emails that were exchanged between Philip Menares, an account executive with Outfront Media, and Mr. Taylor, the respondent. These emails will show, again, Mr. Taylor's connection to the Zhao campaign and his work on the campaign's behalf, coordinating advertisements and billboards. These were obtained from the same civil lawsuit by Mr. Zumwalt.
You know who submitted these exhibits in
It was
that?
the plaintiffs in that case.
Again, to me, this seems to satisfy the evidentiary rule that I've laid out. Any concerns from my colleagues? Seeing none, I think we'll admit
Thank
this
you.
as well.
Investigator Wilson, please pull up Exhibit G, page 1. On the bottom half of the page, you can see an email from Philip Menares, the account executive listed on the contract that you just saw, to the respondent, Paul Taylor, titled SF Poster Proposal. This email was sent on September 25th, and I will read the highlighted portions. Paul, good afternoon. We cleared one hurdle, just waiting for the final blessing. Attached is a proposal for what we can do for a 10/7/19 start, and a location map, although I'm certain you are familiar with the locations. As a reminder, the posters paid for by the Zhao campaign and shown on the contract in the prior exhibit began on October 7th, 2019, the date reflected in this email. Combined with other exhibits, the Enforcement Division believe this shows that Mr. Taylor represented the Zhao campaign in working with Outfront and advertising vendors to secure posters around the city for the campaign's advertisements. We now move to introduce Exhibit D, which is an email from Mr. Taylor to the Ethics Commission on behalf of the Zhao for Mayor campaign. Commission staff pulled this email from our own email database.
From our own what?
Email database. This is, again, D as in dog.
This looks like an email to Mr. Zumwalt. No objection from me. I'm looking at my colleagues. Yeah, we'll admit Exhibit D.
Thank you. Investigator Wilson, please pull up page 1 of Exhibit D. On page 1, we can see that Mr. Taylor sent an email to the Ethics Commission on August 26th, 2019. The email has no subject line or text. It includes 2 attachments showing 2 virtually identical advertisements. If Mr. Wilson could please move to page 2 and then zoom out. On page 2, you can see advertisements clearly. This advertisement in the future will be referred to as the Super Mayor advertisement. It identifies the candidate, Ellen Lee Zhao. It reads, vote November 5th for Super Mayor Ellen Lee Zhao. No mail-in ballots. It has an image of Ellen Lee Zhao supposedly in superhero costume. Advertisement refers to her as Super Mayor. and includes a disclaimer on the bottom that it was paid for by the Ellen Lee Zhao for Mayor campaign. This exhibit shows the respondent, Paul Taylor, emailing the Ethics Commission to provide a copy of this advertisement on behalf of the campaign. Thank you, Mr. Wilson. You can take this exhibit down. So combined together, these 5 exhibits show that the Zhao for Mayor campaign paid Mr. Taylor through his company, What Engineering, for his services in producing campaign advertisements and working with vendors to turn those advertisements into billboards. Further, Mr. Taylor represented himself as an agent of the campaign to both Outfront Media when coordinating with them on a contract for campaign ads and to the Ethics Commission. I will now move to introduce a series of exhibits just for the commissioner reference in their packet. It will be J, L, M, N, and O, so almost all in a row, but I will go one by one again. These all have the same source and the same relevance. They contain social media posts, including copies of 5 ads produced by the Zhao for Mayor campaign. We will later show that the ads produced by AFPAC were identical to these ads put out by the campaign, which is relevant for determining coordination. All were social media posts retrieved through investigation by Mr. Zumwalt, who took screenshots after confirming the campaign's Twitter account through its website. I would also note that that account, the Twitter account and website, are still active as Ellen Lee Zhao is running for mayor currently.
So these are all from the same Twitter account?
There is one that when we scroll to one page, there's a Facebook post, and I will, before I move to introduce that, I will explain that it's multiple things, so you can consider it separately.
Thank you.
So I will start by moving to introduce Exhibit J. Again, this is just a social media post from the Ellen Lee Zhao for Mayor's Twitter account, screenshotted by Mr. Zumwalt, is the part of the exhibit we will be showing on page 1.
Seeing no concerns, I think any concerns from my colleagues? None. Admitted. Exhibit J.
Mr. Wilson, if you could please pull up Exhibit J, page 1. At the top here, you can see this is a tweet posted by the Ellen for SF Mayor campaign Twitter account. In the bottom half, you can see an advertisement with the same image and words as that sent to the Ethics Commission by the respondent in the prior exhibit. It's a disclaimer that it was paid for by the campaign, highlighted at the bottom of the ad. And then at the bottom of the social media post highlighted, you can see it was posted on August 15th, 2019. Again, this ad will be referred to as Super Mayor. I will now move to admit Exhibit L. It is an ad. It is a separate ad produced by the campaign. It was pulled from the Zhao for Mayor campaign Twitter account by the same methods.
J like a Joker? Sorry.
Sorry, L.
L, my bad.
Yes.
L. Yeah, admitted, same reasoning.
Okay. Mr. Wilson, please pull up Exhibit L, page 1. This shows an ad that will be referred to as Werewolves. Again, highlighted at the top is the campaign Twitter account. Features a reference to Mayor Zhao and a Werewolves of London tour bus. There is a similar disclaimer at the bottom that it was paid for by the Zhao campaign and a date posted of September 14th. I will now move to admit Exhibit M. This will contain 2 items that we would like to show. The first is a similar ad posted on Twitter by the campaign account. The second is posted on Facebook by the respondent, Mr. Taylor. This was also retrieved through a screenshot of Facebook by investigator Zumwalt.
I apologize. Quick question. My printed version of Exhibit L has a few more pages than the one that was shown.
Yes, we're only...
So the rest of it's not been admitted yet? Were you only intending to admit the first?
Is it all from the same post?
It's all of them are from the social media account. They were all obtained in the same way by Mr. Zumwalt. They are separate posts.
Sorry, I think the question is the 4 pages on that last exhibit,
Yes.
if they're all from the same post.
No, they're not from the same post. They were, I think you can see they're, no, I know. We are moving to admit everything. As part of my presentation, I'm only showing certain parts.
So for clarity, Exhibit L, is that also some of the Facebook?
And Twitter and Facebook, yes.
And I just had a quick question.
Yeah.
Is there a declaration that that was filed, or like that's going to be submitted alongside this? It sounds like there's a lot of pulling from websites and.
Yes, we have a declaration by senior investigator Zumwalt that's submitted it was submitted with the hearing brief.
Got it.
We do also have, I will note, we have Mr. Zumwalt speaking later because of how the evidentiary standards work for this proceeding. We didn't have him here to authenticate every exhibit as we go, but we do have him speaking later. And I believe as part of the process, commissioners are allowed to ask questions to witnesses. So you are welcome to ask him questions about the exhibits. Thank you. So I believe I was moving to admit Exhibit M. This includes ads from the Ellen Lee Jow for Mayor's social media accounts, as well as from Mr. Taylor's Facebook account, which was pulled by Mr. Zumwalt.
These are 3 pages. Just count them all. 1, 2. Exhibit M is 3 pages, and they're all from the same post, right? Good. Is that right?
Yes.
Okay, we'll admit those.
We're going to be showing 2 separate posts here. One is from the Ellen Lee Jow for Mayor campaign, and one is from Mr. Taylor, just to clarify. So if Mr. Wilson could please pull up Exhibit M, page 1. This is the 3rd ad we are showing. It will be referred to as Police. The campaign Twitter account is again highlighted. The ad features a similar cartoon visual, a reference to Ellen Jow by name, and a quote saying she'll enhance police efforts to make SF safe. The bottom is another disclaimer that the campaign paid for the ad, as well as a date posted of August 14th. Mr. Wilson, could you please scroll to the next page and the next post? This is a Facebook post by the respondent, Paul Taylor, on his page, Paul Taylor for 2018 California U.S. Senate, where he posts a similar ad with the same image but different writing in a different language. It does say that it was paid for by the Ellen Lee Jow for Mayor 2019 campaign.
Okay, so just to make sure we're all then on the same page, Exhibit M has pages from different posts, right? This is from Mr. Taylor's account, you're saying, and the other one is from Ms. Jow's. Okay, yeah.
We'll now move to admit Exhibit O. This is going to be a social media post showing a 4th advertisement, again pulled in the same way by Mr. Zumwalt. We will be showing the last page of this exhibit.
And pulled in the same way, you mean this is from the Jow for Mayor Twitter account?
Excuse me, actually, I'd like to start with Exhibit N before O. But yes, it was pulled by investigator Zumwalt. He took a screenshot after confirming the social media account through the campaign website.
And to my colleagues, I'll just note the declaration from Mr. Zumwalt will be, it's available to you and it's been provided to you, but we'll put it on the website at some point as well as part of the record for this matter. And will be admitted as well.
Thank you. If Mr. Wilson could please pull up Exhibit N. This shows an ad that will be referred to as Needles. At the top, the campaign Twitter account's highlighted. The ad shows a reference by name to Mayor Jow and states that she will stop the needle giveaway. It includes a needle on the beach. At the bottom, highlighted is a disclaimer saying the campaign paid for the ad and a date posted of September 10th. The final exhibit that I move to admit for this portion will be Exhibit O. Again, we'll be showing the final page. Again, this will be campaign social media posts identified by Mr. Zumwalt and screenshotted after confirming the accounts on the campaign website.
I see 2 pages on Exhibit O, is that right?
Yes, we will be showing the final page. We move to admit the entire exhibit.
And same reasoning, we'll admit that as well.
Mr. Wilson, please pull up Exhibit O, final page. This shows an advertisement that will be referred to as Lombard. So first, at the top, you can see the campaign Twitter account highlighted. And just for folks looking at the screen, Mr. Wilson, if you could please zoom in on the bottom, just so we can see the advertisement at the bottom, if possible. The ad depicts a cartoon version of a curvy street which appears to be the famous Lombard Street in San Francisco. It includes the line, "coming to a street near you." At the bottom, highlighted, is a disclaimer that the campaign paid for it, and again, a date posted of September 25th. Thank you, Mr. Wilson. So later in this case, as I mentioned, we will show that all 5 ads are virtually identical to ads later purchased by AFPAC through Mr. Taylor's efforts and put on billboards. In those cases, the ads instead have disclaimers that AFPAC paid for them rather than the campaign. Having established Mr. Taylor's connection to the Jow for Mayor campaign and his work for them in producing advertisements and billboards, I would now like to call Mr. Mark Tsuneshi to testify. Mr. Tsuneshi was the president of the Asian American Freedom PAC at all times relevant to this case.
Mr. D'Amico, sorry, before you do that, you said having established. I would like you, if you can, we just went through a bunch of exhibits. Can you just tie it together very succinctly? What I gathered from what you showed us is that basically the ads are identical, and by virtue of that, is that the association you're pointing to?
Excuse me?
Just pull the exhibits together that we all admitted. Because I think you said that we've established something, but I'd like you to establish it for all of us.
Sure. Through the entirety of all of the exhibits, first we established that Mr. Taylor Mr. Taylor provided services to the Ellen Lee Jow for Mayor campaign. He coordinated with Outfront Media to post billboards. He sent copies of at least one of those billboards to the Ethics Commission with disclaimers. Separately, we established that there were 5 advertisements. They are the Werewolves, Needles, Police, Lombard, and Super Mayor advertisements that were posted by the campaign with a campaign disclaimer. And we will later show that those advertisements were coordinated by Mr. Taylor and replicated with AFPAC's expenditure.
I have a question about the email to the ethics staff.
Yes.
Why, I gather that the email itself had no subject, no text, but why would someone, is there some process whereby advertisement is emailed to commission staff? What do you infer from that?
I was not with the Ethics Commission when that was sent, so I can't speak. I can ask our investigator about that, but we can infer that it was sent as a means of fulfilling a legal obligation to report an advertisement that the campaign put out to the Ethics Commission. Physical billboards were also dropped off at the Ethics Commission's office.
Going back to Exhibit G, which is the email from Outfront. Was it Outfront?
Yes.
Maybe that's Paul Taylor.
I believe it was Philip Menares, the account executive, yeah.
Is there anything indicating whether Paul Taylor responded to?
We don't have emails that show that, no.
This is from the public docket in that federal litigation?
Yes, yes. And because Mr. Taylor did not comply with the subpoena that we issued.
Okay, go ahead, Mr. D'Amico.
At this point, I would like to call Mr. Tsuneshi, who is was the president of Asian American Freedom PAC. He can speak to Mr. Taylor's involvement in AFPAC's $10,000 expenditure that supported the Jow for Mayor campaign.
Please go ahead.
Okay, I believe someone is retrieving him. He's just in the back room.
You know, Mr. D'Amico, of all the exhibits you've got, how many did we go through? I'm curious how many we've introduced out of the bulk that you've got.
We've gone through 10. I think I will be introducing another 10 or 12, most during this testimony.
Would you mind just listing those, if you have a minute, those letters one more time? I tried to take notes, but I want to make sure I don't miss any.
So we have already admitted exhibits I, B as in Brown, H, G, D as in dog, J, L, M, N, and O.
Thank you.
Could you please state your name for the record?
My name is Mark Tsuneshi.
Great. Before we proceed, would the...
Yeah, I'm going to swear him in. Thank you, Mr. D'Amico. Sir, would you raise your right hand? Do you solemnly state or affirm under penalty of perjury that the evidence you give in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir, and thank you for being here.
Thank you for being here, Mr. Tsuneshi. I want to start with, in 2019, were you associated with the Asian American Freedom PAC?
Yes, I was.
What was your role?
2019, I was president.
Okay. And do you know the respondent, Mr. Paul Allen Taylor?
Do I know him?
Yes.
He reached out to me through email when he found out who I was.
Okay. So you do know him?
I know him, yes.
Okay. And so could you just repeat how you first got connected with him?
I received an email regarding a campaign. They know that our Asian PAC supports Asian candidates, and he wanted us to look at an Asian candidate.
Okay. And did he mention who that candidate was at that
Yes,
time?
he mentioned her name, Ellen Liesel.
Okay. And how did you respond to his request?
We're from Southern Cal. I'm not real familiar with the Northern Cal candidates and races. So I really didn't know anything about her.
Okay. And did AFPAC have money to spend on a race in the Bay Area?
No, we didn't at the time. So we weren't really interested in this race.
Okay. Did you communicate that to Mr. Taylor?
Yes, and I think what was communicated was that he had a donor that would donate on behalf of the candidate. So that's why he thought it would be good for us to be involved, because we wouldn't have to come out of our pocket for it, basically.
Okay, so he had a donor who could potentially give you money to support this candidate.
Yes.
And just to clarify, up until that point, how involved had AFPAC been in San Francisco or Bay Area races?
Zero.
Zero, okay. Where did you operate?
Southern California.
Okay, thank you. Now, moving on, did you ever end up meeting the candidate, Ellen Lee Zhao?
So he asked me to fly up to meet with the donor. And at that time, I've never met Miss Sal, but he agreed. I was staying in a hotel near the airport. He would bring her by for breakfast prior to my meeting with the donor.
Okay. When you say he would bring her by, could you clarify?
Paul brought Miss Sal by my hotel lobby where I was having coffee and breakfast.
Okay. So you met with the candidate, Ellen Lee Zhao?
Yes, met her briefly. We had a nice little conversation, get to know each other. Just first time I met her. Seemed a very nice person. That was it. And then I had to leave, and they had to leave, so.
Okay. And where did you go after the meeting with the candidate?
I went to visit the donor who lived up in downtown San Francisco.
Okay. How did you get the address?
I was given the address by Mr. Taylor.
Okay. And did Mr. Taylor attend that meeting?
No, he didn't initially, because it was just supposed to be me. And to get to know who the donor was, I didn't know who she was.
Okay.
Mr. Taylor came in when I was leaving toward the tail end.
Okay. And so he did come in eventually?
Yes, toward the tail end.
Okay. What is the name of this donor?
Name of this donor is Margaret Liu.
Margaret Liu?
Yes.
Okay. And was there any discussion at that meeting of what the money might be used for?
So Ms. Liu expressed that this money would be used to support Ms. Zhao. And I don't even know that she had a relationship with Ms. Zhao. It wasn't really clear. I think our discussion was it was going to be an independent expenditure ad, and that it would be run with billboards that Mr. Taylor had said he had already designed or created.
Okay. So Mr. Taylor said he already designed billboards?
Well, he said he had print. He showed me a poster board of the proposed ad, and it was a cartoon. It was a couple cartoon ads.
Okay. And did that ad resemble one of the ads that AFPAC eventually ended up?
I think I just left it up to him because I don't have any experience with that campaign up in San Francisco, and we don't know who he contracted to do the artwork. But to me, it was a cute thing. It was a superhero flying over the city. So I just said, I'll leave it. We left it up to him.
Thank you. Just briefly, I want to note for commissioners that all witnesses have been sequestered in a back room and have not been present for any part of the meeting up until this point. Did you see the candidate Ellen Lee Zhao again before you left San Francisco?
She did text me and said she missed that in my breakfast. She wanted to take a picture with me. So she met me outside on the street, a few blocks away, because I'd parked and I had walked. And we just took a quick picture on the sidewalk, and then she left.
Okay. So she met you a few blocks outside where you met with the donor?
Yes.
Okay.
Yes.
And did Miss Margaret Liu end up making a contribution to AFPAC?
Yes, she did.
How much was that for?
It was $10,000.
Okay. I would now like to move to introduce Exhibit S. This is a copy of the Form 460 filed by AFPAC. It will show that payment or that contribution. This was obtained from public filings by Mr. Zumwalt.
Just give me 1 second to catch up. This appears to be a 4-page Form 460 filed by the Ellen Lee Zhao for Mayor 2019 campaign. And this is pulled from the...
This is Exhibit S.
Sorry, I'm looking at my mistake. Thank you, Mr. D'Amico. Appears to be a 4-page Form 460 filed by the Asian American Freedom Political Action Committee. We're on the right page?
Yes.
Thank you. And this was pulled from the ASF ethics website?
I believe this was pulled from the state website.
State website.
Yeah.
Thank you. Yeah, that'll be admitted, seeing no concerns from my colleagues.
Great. Mr. Wilson, could you please pull up page 1 of Exhibit S? Great. At the top right, highlighted, you can see this is a Form 460 covering the period from July 1st, 2019 to December 31st, 2019. The top left, the name of the filer is the Asian American Freedom PAC. Highlighted at the bottom is a relevant entry, a contribution from one Margaret Liu for $10,000 made to the PAC September 16th, 2019. Mr. Wilson, you can take this exhibit down. Thank you. Mr. Tsuneshi, what did AFPAC do with that $10,000?
Well, we directed our treasurer, Sin Ivory, to turn around, and Margaret Liu's request was that to be used for that billboard ad. So we directed those funds to be delivered to cover the cost of those ads. I don't remember if it was sent to the billboard company or our treasurer forwarded that check.
Okay. You said that the individual was named Sin Ivory?
Yes, she's our compliance treasurer.
Okay. And do you remember the name of the company or individual that you paid for the billboards?
No, she handled it. I wasn't aware of who handled that on that end. I just was, my agreement with Ms. Liu was the total donation would be forwarded in completely.
Okay.
So we didn't deduct anything. We just sent it.
Okay. I would like to move to admit two exhibits now. I'd like to start with Exhibit T. This is an email between Mr. Tsuneshi and Sin Ivory related to this expenditure. It was obtained by Mr. Zumwalt from Mr. Tsuneshi.
Mr. D'Amico, I have a question about Exhibit S before we move on, if that's
Yes.
okay. What is the date of that Form 460 filing? When was it
The
filed?
Form 460 was, is that listed on there? It would have been due to be filed in January of 2020 because it covers the entire back half of January of 2019. I don't have the date that it was actually filed in front of me.
Just for clarity, is this the Form 460 that was belatedly filed according to some of the counts here?
According to what?
Some of the counts against Mr. Taylor?
No, this is...
But there's a disclosure on the third page of it that there was independent expenditure made to the Ellen Lee Zhao for mayor campaign.
Yes, so the counts are that Mr. Taylor caused this expenditure to be a contribution by coordinating it, which means it was so yes, the third page citation of the independent expenditure, the enforcement division's claim is that was incorrect and it is a contribution because it was coordinated. Yes.
Thank you for clarifying.
Thank you. So we're now moving to admit Exhibit T, which is an email between Mr. Suneshi and Ms. Ivory. Again, this was obtained by Mr. Zumwalt from Mr. Suneshi.
So, Mr. Suneshi, you provided this email to the ethics staff, Exhibit T. He can't see it, but Mr. D'Amico, do you have a copy you can show him?
Yeah, it looks like my email.
Okay,
Do you have
well,
any reason to doubt that it's your email?
Oh, Clear Channel. I see. Yeah, that looks right.
okay, that's submitted. Thank you.
Thank you. Mr. Wilson, could you please pull up the bottom of page 1 of Exhibit T? So I'd like to draw your attention to the bottom of page 1 here, the highlighted portion showing an email from Mr. Suneshi to Sin Ivory, Margaret Liu, and the respondent Paul Allen Taylor. It's titled $10,000 Donation to the Asian American Freedom Pack. The highlighted portion reads, please forward a check in the amount of $10,000 directly to the name and address below so that they may purchase billboards for Ellen Zhao's campaign. Later it reads, please forward our Asian American Freedom Pack receipt directly to Margaret Liu. Investigator Wilson, if you could just show the bottom of this email here, you can see highlighted, it states check payable to Clear Channel Outdoors. This exhibit shows the PAC using the $10,000 contributed by Margaret Liu to pay Clear Channel for billboards supporting the Zhao campaign. It also shows Mr. Suneshi including respondent Paul Taylor on the email. This email, I will note, came on the same day that the contribution from Margaret Liu to AFPAC came, according to the prior exhibit. Moving on, Exhibit AA is a contract between AFPAC and Clear Channel Outdoors, obtained through investigation by Mr. Zumwalt. If the commission wants to follow the same approach, I can show this to Mr. Suneshi first before.
Can I just ask Mr. Suneshi a couple questions about this exhibit before we move on?
Sure, that's up to the chair, yeah.
Mr. Suneshi, thank you for being here. At the time that you received the $10,000 donation from Ms. Liu, was it your understanding that Mr. Taylor was working on behalf of Ms. Zhao's campaign?
Oh, working on behalf of what?
Ms. Zhao's campaign?
I asked that question and I was told he was not.
By whom?
Him. He said he was a friend.
Okay, and that was at the time?
I think at our breakfast meeting, I asked what relation does he have to her campaign, and I did check her website. I didn't see his name, and I asked if he was connected to her campaign.
And you asked him if he was connected to the campaign?
Yes.
And he said no?
He said no.
Okay, thank you.
I have just
Well, he said they were friends. Let me care.
My follow-up question, was his denial the basis for your belief that this would constitute an independent expenditure?
I'm sorry.
Was his denial of a relationship with the campaign the basis for your classification of this donation as an independent expenditure?
Yes, we would not have made the contribution if we had known he was affiliated with her campaign in any manner. So.
And your testimony is that he misrepresented that he was not affiliated with the campaign?
I'm sorry, what?
Your testimony is that he made a representation to you that he was not affiliated with the campaign?
He was not affiliated with her campaign, yes.
Just another quick question. it sounds like if he provided you the donor who's going to pay for the work you were doing, why did he need your PAC at all? Did you ask him that? Like,
Well, no, I asked Miss Liu that question, and Miss Liu's a very elderly woman. She's a private individual, and she didn't wish her name to be released. So she thought she would have a little bit more anonymity donating it through the PAC. She's a long-time Democratic supporter of over the years, and she just felt uncomfortable if her name was to be leaked.
okay, thank you.
So just to go back to my question, did the commissioners want me to show, there are going to be about, I believe, 5 more exhibits during your testimony. Thank you again for your patience. Would you like me to show them to Mr. Tsuneshi?
Yes, sir. Which one were we on?
So we are on Exhibit AA. This is a contract between AFPAC and Clear Channel Outdoors for the billboards purchased.
Are any of those 5 exhibits the same source or the same categories such that we could look at them at the same time, admit them at the same time?
So the next 3 after this one are all emails, and they were all obtained from Mr. Tsuneshi.
Okay, that's great.
This one is obviously not an email; it's a contract.
Okay, perfect. So we'll deal with this one by itself, and then you can combine the other 3.
Great.
Yes,
So this
please,
is AA.
Please show Mr. Tsuneshi the contract.
Okay.
Sir, Mr. D'Amico, what do you purport that this is?
This is a contract between AFPAC and Clear Channel Outdoors for the purchase of billboards.
And Mr. Tsuneshi, do you have any reason to believe that's not what this
sorry?
is? Do you have any reason to believe that this exhibit AA is not what Mr. D'Amico represented that it is?
It looks so accurate. I mean, I don't really. Yeah, it looks fine.
Okay, that's admitted then, exhibit AA.
Thank you, Mr. Wilson. Please pull up the bottom. Please pull up page 1 of Exhibit AA. So I'll start on page 1 of the contract here at the top highlighted. It's a contract for outdoor advertising, Clear Channel Outdoor. At the highlighted portions on the top right, you can see the name listed is the Asian American Freedom PAC, and the product name is Ellen Zhao for mayor. On the left, highlighted in the middle, we can see the contract is for, quote, posters 10/7 to 11/3. Please note these are the exact same dates as the contract the Zhao campaign signed with Outfront Media, arranged through respondent Paul Taylor, shown through exhibits earlier. Near that, you can see a total of 16 posters listed on the contract, and toward the bottom right, you can see a contract total of $10,000 highlighted. On the bottom of the page, you can see highlighted the name Cheryl Weierstock. Ms. Weierstock was an account manager at Clear Channel Outdoors. If Mr. Wilson could please pull up page 4 of the exhibit at this point. On the left side in the middle of the page, you can see a series of 4-digit numbers highlighted. These represent locations. The Enforcement Division will show later that many of these correspond with the same 4-digit numbers sent to Ms. Weierstock by the respondent Paul Taylor. We will show that through email.
What is the difference between the contract on page 1 and the contract on page 3?
This one shows the locations. Page 1 does not show the locations.
We know which one is final because neither appear to be signed. And the total invoice amounts are different.
I believe the top one is final. The first page, yes. Excuse me, yes, is final.
Is that correct, Mr. Tsuneshi?
I'm sorry, what?
Is it your understanding that the first page of Exhibit AA is the final contract that was executed AFPAC and Clear Channel
It looks okay to me. I mean, I didn't see these in advance, so. I'm sorry.
You mean in advance of today, or?
No, I never saw these items, posters or whatever.
Never saw them when this contract was entered? Or?
No.
I understand, but do you have any reason to think this is not the contract between?
I'm sorry, what?
Do you have any reason to think this is not the contract?
No, it looks right, but I don't recall a lot of this specifics regarding the poster size or whatever.
Okay, thank you.
To that point, Mr. Suneshi, had you worked with Clear Channel before?
Never.
Mr. Wilson, you can take down this exhibit. Thank you. So who coordinated with Clear Channel and provided details for these billboards?
Mr. Taylor.
Okay. Now is when I would like to move to introduce, there are 3 exhibits that are all emails between Cheryl Wyerstock, an account manager at Clear Channel, Mr. Taylor, and Mr. Suneshi. All of these emails were obtained by Mr. Zumwalt from a document request to Mr. Suneshi. So Mr. Suneshi provided all of these. These are exhibits U, Y, and CC. And if it works for the chair, we could show all of the emails at once to Mr. Suneshi.
Yeah, let me just ask, does Mr. Zumwalt's declaration address how he got these emails, that they're from Mr. Suneshi?
Yes, it should.
And was the contract earlier also received from the witness?
The contract was received from Clear Channel Outdoors.
That was exhibits U and, what were the exhibits? U?
Or U, Y, and CC. Thank you.
Okay.
Mr. D'Amico, do you happen to have the declaration that Mr. Zumwalt provided handy?
It's exhibit FF.
It's in here? Oh, okay. I think if these are addressed in that declaration, we can probably just admit them on that basis. I think next time we do this, having tabs will make it a little bit quicker. For tabs. I think we can do that. There we go, FF. Sir, I'm just reviewing the declaration to pinpoint the paragraphs that address those exhibits. Mr. D'Amico, do you happen to know which paragraphs of the declaration are going to relate to the exhibits you're about to address?
Paragraph 9 relates to at least one exhibit.
I'm specifically asking about the emails you're about to show us.
Paragraph 9 relates.
This just says he reviewed it, but it doesn't explain where it came from. So it might be helpful to get Mr. Suneshi to just confirm.
Sure. Yeah, I agree. So let's show him. Maybe he already has the hard copies.
He does, yes.
Great.
Yes.
Mr. Suneshi, can you confirm? I think you have 3 different exhibits in front of you. They each contain emails. Can you confirm that you provided those to the Ethics Commission staff?
I'm sorry, could you repeat that?
Sure. I believe you have 3 hard copy exhibits in front of you. Mr. D'Amico, can you just remind me the letters of those exhibits?
U, Y, and CC.
Are those the ones you have, Mr. Suneshi?
Yes, I do have them.
Can you confirm that those 3 contain emails that you provided to the commission staff?
Yes, they look like the ones.
Great. We'll admit those 3.
Great, thank you. So if Mr. Wilson could please pull up page 1 of Exhibit U. At the top of page 1 highlighted, we can see an email from Ms. Wyerstock to Mr. Taylor, the respondent, on September 18th, copying Ellen Zhao. Highlighted, she states, quote, "The specs are attached so you can get started on creative." Just below, hours earlier, Mr. Taylor had emailed Ms. Weierstock, copying the candidate, Ellen Zhao. Highlighted, Mr. Taylor wrote, "Okay, understood. Here is the list so far, junior size," followed by a list of 4-digit numbers. If Investigator Wilson could show the remainder of this email.
And just remind us, Ms. Weierstock is the Clear Channel rep?
She is the account executive at Clear Channel Outdoors, listed on the contract.
Thank you.
Mr. Taylor then writes the words "larger size" and then provides 2 more 4-digit numbers. These have all been exhibited, so commissioners can check at any point, but I will just note that 8 of the 10 4-digit numbers are listed in this email are also on the contract between Clear Channel and AFPAC already showed.
Mr. Sineshi, do you have any understanding why at the email on the first page from Mr. Taylor to Ms. Weierstock and yourself, that Mr. Taylor included Ms. Zhao in the email chain?
Could I ask you to speak into the mic? I'm a little hard of hearing. I'm sorry.
Thank you for reminding me. I'm looking at the first page of Exhibit U.
Yes.
The second email there, the email at 8:43 a.m. from Mr. Taylor to Ms. Weierstock and yourself and Ms. Zhao. Do you have any understanding why Mr. Taylor included Ms. Zhao on that email?
Why Mr. Taylor would what?
Included Ms. Zhao on that email?
I have not. I'm not sure. And looking at this, I don't recall seeing her name on it, but it is on there, so.
Okay, thank you.
Mr. Wilson, could you please show the highlighted email on page 3 of this exhibit? This is the same exhibit, Exhibit U. Page 3, there's a highlighted email. We can see an email from Ms. Weierstock on September 17th saying to Mr. Taylor, "Where would the funds be coming from? I have not been contacted by anyone but you." His emails show that Mr. Taylor coordinated with an account manager at Clear Channel about the content and the locations of the billboards, and in one email suggested that the representative had not heard from anyone else except Ms. Taylor about this purchase. Mr. Taylor about this purchase. The next exhibit, Mr. Wilson, could you please show Exhibit Y? That'll be page 1 on Exhibit Y. At the top of this page, at the top of this exhibit, highlighted, you can see the email from Ms. Weierstock to Mr. Suneshi copying Paul Taylor. The highlighted portion, Ms. Weierstock writes, "Waiting on artwork from Paul." This exhibit shows that the respondent worked with Clear Channel on artwork for their billboards. Finally, Mr. Wilson, could you please pull this down and show Exhibit CC, page 1? Here at the top, you can see Mr. Taylor has forwarded an email to Mr. Suneshi on September 25th. In the middle of the page, highlighted, we can see what Mr. Taylor forwarded. This is an email also on September 25th from Ms. Weierstock to Mr. Taylor. The highlighted portion reads, "Hi, Paul. See attached for what is contracted. All of the locations you listed below are already on the plan." This exhibit further shows Mr. Taylor selecting locations for the AFPAC billboards. Thank you, Mr. Wilson. Thank you for your patience, Mr. Suneshi. I just have one more exhibit to go through with you, and then we'll wrap up. So I'd like to move on to the actual design of the advertisements. I'd like to introduce Exhibit DD. This is an email from Mr. Taylor to Mr. Suneshi, and this includes attachments, which include the designs of the advertisements purchased by AFPAC. We'll show this to Mr. Suneshi.
Thank you.
DD.
DD.
Mr. Suneshi, do you have Exhibit DD? Do you have Exhibit DD in front of you?
Yes, I do.
Does this look like, do you recognize this?
Yes, they look.
Does this look like an email that you received from, sorry, is this an email that you received from Mr. Taylor?
Yes.
I think you will admit that.
Great. If Mr. Wilson could please show page 1 of Exhibit DD. So here, highlighted, you can see this is an email forwarded by Paul Taylor to Mark Suneshi on October 1st, subject, forward billboards. The text highlighted reads, sent to Clear Channel. Below this is the initial email that was forwarded by Mr. Taylor. The highlighted portion shows he received earlier that day. I will now show you the attachments to the email sent by Mr. Taylor to Mr. Suneshi. Mr. Wilson could please show page 2 of this exhibit. So there are numerous repeats in these sets of triptychs of advertisements paid for by the Asian American Freedom PAC. We'll focus on just a few sets of 3. First, I want to note all advertisements throughout the attachment read paid for by the Asian American Freedom Political Action Committee. Now, in the first set on the left side, an ad that includes a reference to Mayor Zhao and a Werewolves of London tour bus. This is substantially similar to the Werewolves ad shown earlier, posted to the Zhao campaign Twitter, with a disclaimer that it was paid for by the campaign.
When you say substantially similar, do you mean identical except for that disclaimer? Or there?
Yes. Yes. Some of them also, as you can see as we scroll down, some ads have language in English. In all different languages, the ads have. So sometimes that is what is different, is the language. Next to that is an ad showing Super Mayor Ellen Lee Zhao and encouraging people to vote for her. This is substantially similar to the Super Mayor ad shown earlier, which was sent by Mr. Taylor to the Ethics Commission in August, with a disclaimer saying it was paid for by the campaign. Next to that, an ad depicting a curvy street and reading, coming to a street near you. This is substantially similar to the Lombard ad shown earlier, posted to the Zhao campaign Twitter, with a disclaimer that it was paid for by the campaign. Investigator Wilson, please move down to the 6th and 7th sets. The disclaimers on those will be highlighted. Thank you. In the 6th on the right, you will see an ad including the phrase, Mayor Zhao to the rescue, and the same image as the ad released by the campaign Police. This is substantially similar to that police ad shown earlier, with a disclaimer that it had been paid for by the campaign. In the next set, on the left, you will see an ad showing a needle on the beach with the statement, Mayor Zhao will stop the needle giveaway. Again, this is substantially similar to the needles ad shown earlier, except the disclaimer is different. These 5 ads, Super Mayor, Werewolves, Needles, Police, and Lombard, are the only 5 in this attachment, arranged in different combinations of 3 with text in different languages. All 5 are substantially similar to ads shown earlier, released by the campaign. This exhibit shows 1, that Mr. Taylor sent designs to Clear Channel for these billboards and then forwarded them to Mr. Suneshi to give him a heads up, and 2, that the designs that he sent replicate 5 ads previously produced for and distributed by the Zhao campaign.
I have a question on that point. Mr. Suneshi, I think you said earlier that you did not get involved in the design of the posters. Were you aware, or when you got these posters in the email, did you know from where Mr. Taylor got them? For example, whether they were copied from something else?
I thought it was represented as original artwork for this campaign. I did not know they were used.
Original by Mr. Taylor?
I'm sorry, what?
You thought Mr. Taylor created them?
No, Mr. Taylor said he had someone who did the artwork, and I thought this was original artwork. He showed me a poster board that was going to be used for this.
When you said it was original for this campaign, which campaign are you referring to? When you said he represented it was original artwork for this campaign?
Yes.
Which campaign are you referring to?
Well, the one that Margaret Liu's donation was go toward.
Okay, so your advertising, AFPAC's advertising campaign?
Yes, so we were under the impression that the funds from Margaret Liu would be used specifically for the print ads that were shown us. And we were told that was original artwork for the campaign. So,
I think just the question that we're getting at is, when you say original, you thought they were designed for your independent expenditure campaign,
yes,
not for the candidate's own campaign.
That's correct.
And that you thought that because that's what Mr. Taylor told you? Or from where did you get that belief?
I think he told me, and I didn't even know that was used prior. I didn't know there was artwork prior.
Okay, thank you.
So,
Commissioner Salahi?
I do have an additional question about a slightly different issue, if that's okay. Earlier you were talking about your introductory breakfast with Ms. Zhao and Mr. Taylor.
yes,
Did the subject of Ms. Liu's prospective donation come up at
No.
that breakfast?
no. It was just, I have never met Miss Zhao, and it was more or less, what is she from? What does she do? It was mostly a informal get to know each other. It wasn't very long. It was a brief meeting.
Did the subject of how AFPAC might support her campaign come up during that breakfast?
I think she knew, but I never went into specifics because I had not met Miss Liu. I was not aware if there was going to be a donation. I wasn't going to assure her that we could help in any way because at that point I was unsure. We had met with the donor, and I didn't know what Miss Liu's intention was. And a lot of it would have to do with the donation. If it wasn't going to be a significant donation, we wouldn't really need to be involved.
Did the subject of what AFPAC's ability to support Ms. Zhao's campaign come up at that breakfast?
No, I don't. We didn't speak in specifics. Like I said, the meeting was, I didn't know her, she didn't know me. It's basically background, where are you from, what's your experience, why are you doing this. I was more curious because I wanted to find out, I didn't know anything about her. I wanted to find out her background. So I didn't go into specifics.
Did billboard advertising come up in that meeting at all?
No, did not. I didn't even know about the billboards, to be honest, yet.
Okay, I just have a final few questions.
Sure.
So, were you aware that an independent expenditure cannot be coordinated with a campaign?
Yes, I'm aware of that rule.
And did you intend to comply with?
I intended fully to comply with it, and I told my treasurer, handles other PACs and other political candidates, to make sure we were in compliance with that.
And did you have any knowledge that the campaign had paid for identical advertisements prior to this point?
I'm sorry, repeat.
They already asked, but did you have any knowledge that the campaign had put out identical ads prior to?
I was not aware of any identical ads.
Okay. Do you think you would have gotten involved in this campaign without Mr. Taylor's outreach?
Well, certainly without Mr. Taylor's outreach, we probably wouldn't have been involved because of the donor who he knew. And that was the reason that we flew up, or I flew up.
Okay, nothing further from us.
I have a few more questions, actually. Other than the breakfast meeting with Ms. Zhao, did you ever meet her another time?
Yeah, like I said, I had a brief, she said she didn't take a picture, she wanted to take a picture. So I said, was flying out after the meeting with Miss Liu, so she wants to meet me, she can take a quick picture, which she did.
Did the subject of Ms. Liu's donation come up at that meeting?
No, it did not, and it was just a really brief. She came up to me on the street, we took a picture, and then we left. I didn't discuss the ad with her.
Okay. And other than those two meetings that you described, are there any other communications between you and Ms. Zhao?
I have not met Ms. Zhao since that street meeting. I'm unaware of, there might have been another email or so, but as far as I was concerned, I was dealing mostly with Mr. Taylor.
And did that email have to do with Ms. Liu's donation or the billboard advertisements?
I'm sorry.
Did that email you mentioned with Ms. Zhao have anything to do with the billboard advertisements?
I'm sorry, repeat the question?
You mentioned that there might have been another email between you and Ms. Zhao after those two meetings you had. Is that correct?
When this was all going on, there was a swirl of things going on. And so we were not communicating with Ms. Zhao with regards to the billboards. However, I might have CC'd her accidentally, but I don't really think I CC'd her. It was just, when you hit email, the names pop up, and I don't really believe it was about the billboards. I forgot what it was.
Was it about Miss Lou's donation?
It might have been, but I don't really think I would have put the amount in an email. And if it was an inadvertent thing, and certainly we had not discussed it with Miss Sal. I was real careful not to discuss Miss Lou's donation.
With Miss Zhao?
Yes.
And what steps, if any, did you take to confirm that Mr. Taylor was not working on Miss Zhao's behalf?
Well, I checked Ms. Sal's website. Usually they would list people, or I would see photos on it. I didn't see photos of Mr. Taylor. I didn't see his name as being on the campaign staff. And when I asked Mr. Taylor, he said he was a friend. So.
Is that all? Are those all the steps that you took to confirm that Mr. Taylor was not working on behalf of Ms. Zhao?
I'm sorry?
Are those all the steps that you took to confirm that Mr. Taylor was not working on behalf of Ms. Zhao?
Yeah, when he said, I asked him specifically, and he said no. So, and I didn't see his name showing up anywhere on her materials. So.
Okay, thank you.
Any questions from?
I have just one question. When was the last time you spoke with Mr. Taylor?
He said, "Hi, Mark," as I walked by this morning, but I have not had communications with him. I know under our attorney told him and of course, to stay away. So we've not had communications with him.
Since these communications about the poster?
I'm sorry, what?
You mean since the communications about the poster that we've been discussing?
Since the subpoena, I know he texted or reached out, I forgot, but I said it's inappropriate, and I didn't respond. So we've not had communications.
I just wanted to follow up. You said our attorney.
I'm sorry, what?
Earlier you said our attorney advised against communicating. I think I heard you say our, and I'm just wondering.
My Asian PAC, we have a board member who's an attorney.
Okay.
Any other questions from our colleagues? Mr. D'Amico, you're through with your examination of this witness?
I am, and once you are all done, I would just request, if possible, we do not plan on recalling him, and he did travel for this and does have a flight this afternoon, so if we could dismiss him, if you feel that's appropriate, that would be appreciated.
Yeah, certainly. And Mr. Suneshi, I just want to thank you for being here. I gather you're not a local. I know it's a big burden to be here, but it's invaluable for our work. So thank you so much for taking the time and joining us.
I appreciate it. Thank you very much.
Thank you.
Okay, moving on. I want to note that through Mr. Suneshi's testimony and the exhibits, the Enforcement Division showed that Mr. Taylor, the respondent, reached out directly to the president of AFPAC to connect him, or to tell him about a campaign. He connected him with both the candidate and a donor. He facilitated a $10,000 donation specifically for the purpose of supporting the Zhao campaign, and then he coordinated with Clear Channel Outdoors on numerous details, including location and content of those advertisements paid for by the expenditure. We will tie these facts to the legal framework during our closing statement, but the last part of this case, we would like to focus on Mr. Taylor's withholding of information and obstruction of the investigation, and for that, I would like to call Jeffrey Zumwalt, who's the acting enforcement director for the Ethics Commission and was the senior investigator on this case throughout it.
Mr. D'Amico, before we move on, would you prefer, to the extent that we have questions about how the facts tie to the legal framework, we wait until your closing statement?
Yes.
Okay, thank you.
Thank you.
Great. Yeah, go ahead and please call Mr. Zumwalt.
Okay, great. Someone just went to get him.
thought I was supposed to be here for that, but. Okay, that's fine. Yeah. No, that's totally fine. I just want to make sure I didn't miss anything that I was supposed to be here for. Okay, thank you.
With that one, because I just want to get it in. Could you please state your name for the record?
Jeffrey Zumwalt, last name spelled Z as in zebra, UMWALT.
Okay. And could you please state your current job?
I'm a senior investigative analyst with the San Francisco Ethics Commission, currently serving as the acting director of enforcement.
Sorry, I'm going to swear you in before we get into the testimony.
Yes, thank you.
Mr. Zumwalt, would you raise your right hand, please? Do you solemnly state or affirm under penalty of perjury that the evidence you give in this matter shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And then just please start over with that question that I missed.
Could you please state your current job?
Senior investigative analyst with the San Francisco Ethics Commission, but serving currently as the acting director of enforcement.
And just before we go any further, could you please take a look at Exhibit FF? Do you remember putting together a declaration?
Yes, I do.
Okay. And does that exhibit look familiar to you?
Yes, it does.
Okay. Could you briefly summarize it?
This is a declaration of swearing under the penalty of perjury the investigative steps that I took in this case, various items that I collected as evidence, processes served, and just verifying some of my actions.
Okay. Commissioners, we don't intend to show this and talk about it in detail, but given it was brought up earlier and we have Mr. Zumwalt here, I just wanted to take the opportunity to admit it.
Admit the declaration itself?
Move to, Exhibit FF, the declaration.
Yeah, that's fine. Admit it.
Great. Okay. Moving on. How long have you been in the role of senior investigator?
I've been in this role since February of 2019.
Okay. And what was your role prior to that?
Investigator, where I started in July of 2017.
Okay. Started with the Ethics Commission?
Correct, yes.
And what was your role in this case?
I was the investigator assigned to the initial investigation of it and have worked the case from when we initially started it through today.
Okay. And as part of this, did you reach out to the respondent, Paul Allen Taylor, at any point?
Yes, I did.
Okay. And when did you first reach out to him?
I first reached out to him on September the 16th of 2020.
Okay. How did you reach out?
Phone call.
Did he answer?
Yes, he did.
Okay. And what did you say to him?
I informed him who I was. I said we had an investigation that we were conducting, that I needed to send him a request for some information pertinent to the investigation, and asked him to confirm an email address that I could send it to.
Okay. And did he confirm that?
Yes, he did.
Okay. And did you follow up with the document request?
Yes, I did. I sent it later that day.
Okay. Did he respond at any point?
No, he did not.
Okay. Did you follow up?
Yes, I did. On October 7th and October 28th of 2020, I responded to the email that I'd sent with the document request, just following up on it and asking when we might expect a response.
Okay. And did you get one?
Mr. D'Amico, sorry, quick question. The document request itself, that's not in the exhibit. Is it among the exhibits?
No, it's not.
I'm just curious, is that?
It is, I believe.
Oh,
Yeah. GG maybe? Sorry, I seen it earlier.
Because my question is whether the exhibit itself says compliance is, voluntary and mandatory?
That document request was voluntary.
Okay.
Is it Exhibit GG that
No,
what you
no,
returned?
the document request is not in there.
Great, thank you.
It's not Exhibit A2. There's an administrative subpoena in Exhibit GG. I'm not sure if is that not the same document?
It's not. This was this was not a formal subpoena for a document request.
Request with a list.
Exhibit GG are all documents that the respondent sent to the commission.
That I understand because there's his handwriting on it, but just looking at, sorry, I didn't mean to derail anything, but just looking at pages 1.
That is a copy of the subpoena that we sent to him that he sent back with his writing, but this was an informal document request at the beginning of the investigation before he was a respondent.
Thank
and he
you
was
for
just
clarifying. That was my question.
Okay. When you followed up in October of 2020, did he respond?
No, he did not.
When he didn't respond at all, did you take additional steps to get the relevant documents?
Yes, we did.
What steps did you take?
We then issued an administrative subpoena for documents in December of 2020.
Okay. And did Mr. Taylor ever produce responsive records?
No, he did not.
Okay. Did you attempt to enforce that subpoena?
Yes, we conferred with the city attorney's office about potential enforcement of it.
Okay. And did that yield any results?
No, it did not.
Okay. When did you next reach out to the respondent?
Wait, sorry, I have a question before you get there. I don't want to know about your communications with the city attorney, but how did you try to enforce the subpoena against Mr. Taylor?
We just discussed options with the city attorneys. I know that there was an issue with if it was personal service or not. Being in COVID, we sent the subpoena via mail because we weren't hearing anything back. So then there was a question of personal service. Could we verify service to enforce? Right. That sort of thing.
So I'm just asking, like, what staff actually did. It sounds like you emailed initially the subpoena to the address that he provided you. Is that right?
We mailed it to the address that we had that was the business address where the payments on a 460, where the payments were, the address listed for those payments. That's where we mailed it to at that point to try to do mail service.
But had the initial step been to email it to the email address that he provided you?
I don't know. We did not do it email because we had not received confirmation that he would accept electronic service. So we were trying mail service.
Understood.
Is it your understanding that mail service is valid service for an administrative subpoena?
I know personal service is preferred. We honestly didn't know if the mail service was going to suffice for the service, and that's what kind of led into whether or not this was anything we could even enforce at that point.
And when you said earlier that the enforcement efforts did not yield any results, did you mean that no steps were taken to enforce the subpoena, or that no documents were procured through?
Sure. Kind of both. We had asked, that's when we found out, okay, it doesn't look like this is anything we could enforce. And then simultaneously, yeah, we did not receive anything further at that point.
But no other action was taken to enforce the subpoena?
No, not at that point. We just started taking other investigative routes.
Okay, thank you.
When was the next time you reached out to Mr. Taylor?
August, I believe the 12th of 2022.
Okay, and could you discuss what you did in the interim and why you didn't reach out again?
Sure. So in the interim, we were working other investigative avenues. We were speaking with other individuals that were involved in the case that we had identified as potential witnesses, serving additional subpoenas, additional document requests, trying to gather evidence from other sources, because it just appeared at that point we were not going to receive any documents from Mr. Taylor.
Okay. When you did reach out again, when did you reach out?
I believe August the 12th of 2022.
And how did you reach out?
That was via email.
Okay. Did you receive a response?
No, I did not.
Okay. What did you say in that email?
Basically reminded Mr. Taylor that the investigation was still ongoing, referenced the subpoena that we had mailed in December 2020, and then asked if we would, when we could expect responsive documents to that.
Okay. Did you call at any point?
I did on September 29th of 2022. I did call Mr. Taylor.
Okay. And did he answer?
The phone call was answered and immediately hung up upon, and then I believe I called back again and left a voicemail after that.
Okay. At that point in late September 2022, what steps were being taken to move the investigation and the case forward?
So at that point, we believed we had enough evidence for probable cause, so we were moving forward with drafting a probable cause report to serve in that case.
Okay. And before probable cause was served, had you managed to get any response or contact since that first call?
No, I did not.
Okay. And did investigators serve a probable cause report on the respondent?
Yes, we did.
And did anything accompany that probable cause report?
A subpoena for administrative records from the Ethics Commission.
Okay. Could you tell me why you issued that second subpoena?
For the second subpoena, we were still attempting to gather responsive documents relevant to the case. So we knew we were going to serve the probable cause report, so we were then going to try to serve the subpoena in person to ensure that we had personal service of it.
Okay, and could you describe how and when service was affected on both the subpoena and the probable cause report?
Sure. On October 25th, 2022, we went to Mr. Taylor's home in Hayward, California. Myself and another investigator waited for him outside. We observed him leave. We were going to see if we could serve him in public, but we were unable to, so we waited till he came back home. And when he came back home, I served him with the subpoena in the driveway.
Okay. Did you Did you have him identify himself?
Yeah, so I walked up to him. I said, hi, Paul Taylor, to which he said yes. And then I identified myself as Jeffrey Zumwalt from the San Francisco Ethics Commission and said I have a subpoena for records as well as a probable cause report.
Okay.
That the subpoena reflected in Exhibit
Yes.
G?
Yes.
Dated October 20th, 2022?
Yes.
Okay.
And what did you do with the documents?
I went to hand the subpoena to Mr. Taylor. He did not take it, but as I was handing it to him, I saw it touch his body and kind of crumble up, indicating that he'd been touched by it. And then I asked him, okay, where would you like for me to leave these documents? He initially told me to leave them in my desk. And then I said, can I leave them on your car? And then he began to say he's not going to speak with anyone without his attorney present, and then went and basically locked himself in his garage there in his driveway. So I left the documents immediately outside the gate to his fence.
Okay. And did you send them in any other way?
Yes, so the next day I emailed the same documents to the email addresses I had for him, as well as mailed them through U.S. mail.
And you mailed them to the address where you found him?
Yes, we did.
Okay. Did the respondent ever produce responsive documents to the subpoena or the probable cause report?
Not to my knowledge, no.
Okay. Did the respondent ever send anything to the commission?
Yes, he has.
Okay. What did he send?
He sent in, I believe, end of November, early December 2022, began sending a number of letters to the Ethics Commission.
Okay. And did you read all of these letters?
Yes, I have.
Okay. Could you just briefly say what they contained?
Sure. The first was a conditional acceptance. It listed a number of assertions that the Ethics Commission needed to provide to Mr. Taylor in order to contract or move forward with this process with him. We received reminders of that. And then later, as we continued the enforcement process, we started receiving notices of violation from not responding to the prior conditional acceptance. And along with that, fines that were increasing in value with each notice that we received.
Okay. To your knowledge, did respondent ever submit a response to the probable cause report?
No, he did not.
Okay. Did anything in his letters, at least to the best of your recollection, address the substance of the case?
No, it did not.
Okay. Did any of them address a process contained in the Commission's enforcement regulations?
Not to my knowledge, no.
Okay. Based on your experience, what did you think the point of the letters was?
It was my interpretation. The point of these letters was for us to stop our administrative enforcement action.
Okay. I'm going to move to introduce Exhibit GG. This is a copy of the letters sent over the course of almost a year by Mr. Taylor to the Ethics Commission and Commission staff. Happy to have Mr. Zumwalt take a look at them briefly and confirm that. Yeah. Oh, wait, let me take the back off. Thanks.
Mr. Zumwalt, is this a copy of the subpoena you served on Mr. Taylor in October 22?
Yes, it is, with the address redacted, yes. And this is what we received back, I believe, end of November, early December, but this is the same subpoena that I served.
So the handwriting that's on there was on the version of the subpoena that you received back?
It was on the version we received, not on the version I served.
Thank you. Admitted, the Exhibit GG.
It's admitted, did you say?
Yes.
Okay, thank you. Mr. Wilson, could you please pull up page 1 of the exhibit? I know you were just asked about this, but you recognize this page, Mr. Zumwalt?
Yes, I do.
Can you just briefly again describe
Sure,
your interpretation of it?
The first page of the administrative subpoena that I served on October 25th, 2022, that we received back, again, either late November, early December 2022, mailed to the Office of the Ethics Commission with writing on the front of it.
Okay. Mr. Wilson, could you please pull up the next highlighted portion on page 28 of the exhibit?
This is Eamon Wilson. Is this the correct page, Zach?
It should be, yes, but it should be. Could you scroll down to see if there's a highlighted portion? Could you continue scrolling just to see if there's a highlight? There should be a highlighted portion lower down on the exhibit. If not, there just may have been a technical error, but you can just go up.
May not be this version.
Yeah. So do you recognize this part of the document? Can you go to the top of that page? Yeah.
Yes, I do.
Okay. Is this one of the letters that Mr. Taylor sent?
Yes, this is one of the notices of violation that we received.
Okay. Do you recall what Mr. Taylor asked for in some of these notices of violation?
It was he asked for a number of assertions as to our jurisdiction over different enforcement matters. And then there was also a number of lists of violations that the Ethics Commission is alleged to have violated.
Okay. There's about 50 to 60 pages of these letters. I won't go through all of them. We have them submitted. Some of them were also sent to the commissioners, so you may have them or have already reviewed them. So I won't go into detail further.
But they're all part of Exhibit GG?
They are all part of Exhibit GG, yes.
I have some questions.
Yes, of course.
You said it was personally served on October 25th, 2022?
That's correct.
And do you have an understanding of what the respondent's deadline to respond was?
So our response deadline for documents is 25 days.
Okay. And the objection deadline is 20 days? The deadline for respondent to object to an administrative subpoena is?
I'm not certain of the objection deadline.
Did any of Mr. Taylor's correspondence regarding the administrative subpoena arrive prior to 25 days after October 25th, which I'm trying to figure out for you right now?
Commissioner, the Deputy City Attorney noted that it's 5 days for an objection.
Yeah, I'm looking at your regulations. So it's under Section 5, Investigation, on page 6. It says any person or entity served with a subpoena or subpoena ducus taken may object by filing written objections with the executive director at least 5 calendar days before the time required for attendance or production of the requested documents.
Thank you. And in this instance, the time required for compliance was 25 days after October 25th, 2022?
Yes.
I just need a moment to figure out that.
Well, do we know the date of the response that you received?
Not off the top of my head, but I believe I'd have it in my notes somewhere that I could.
November 16th.
November 16th.
Sorry.
And that was the earliest response from the respondent?
If it was November 16th, then yes, that was.
Is November 16th the date of the response or the 25 days that you just calculated?
It's the date of the response. It's in the document at the top.
Okay.
This was the first response that he sent. This is the first.
Isn't that
Sorry,
exactly?
yeah, feel free to do the calculations. Yeah. Otherwise, but I'm just stating the first document we got from Mr. Taylor.
So I have 25 days from October 25th would be November 19th. Although I'm not 100% sure. I think we have to look into that. But November 19th is a Saturday, so I don't know if that kicks things for any reason. But your response date was November 16th. That was the earliest response from Mr. Taylor.
That sounds correct, yes, sir.
Thank you.
Did investigators ever offer to settle?
Yes, we did.
Okay. Did Mr. Taylor express an interest in settling?
To my knowledge, no, he did not.
Okay. Around how many investigations have you been a part of with the Ethics Commission?
I'd say roughly between 225 and 250, maybe.
Okay. And do you regularly send document requests?
Yes, we do.
Okay. And do you regularly interview witnesses?
Yes, I do.
And have you issued subpoenas before?
Yes, I have.
Okay. How does the witnesses' lack of compliance compare with the rest of your cases?
I mean, of course, we have people that don't comply, that don't want to speak with us, that we have to try to get compliance through other means. But I've never received responses like this in my career here.
Okay. I have no further questions.
Did you take steps to enforce the subpoena after receiving Mr. Taylor's correspondence on November 16th?
Yes, we did that as well.
What were those steps?
Again, we conferred with the city attorney's office and requested that they enforce the subpoena.
Would that be a petition to the Superior Court?
I believe that's what they would do, but they would have to take that up on our behalf. So we reached out to them and asked them to enforce this.
Was that step taken to your knowledge?
I believe there were initial steps.
Let me just, we don't want to know what you discussed with your attorney. Sure. I think the question is whether factually, did staff move to either compel the subpoena in Superior Court or otherwise ask the Superior Court to get involved? And I didn't mean to cut in for you, Mr. Salat.
No, that's correct. Yeah, we don't want the privileged
Sure.
information.
No, we'd have to ask the city attorney's office if they could move it forward. And to my knowledge, it was not.
Okay. I can speak to this if you'd like, either now or at the end.
As you like. Yeah.
Okay. So initially, the city attorney's office suggested that they attempt to meet and confer, which they said was typically the first step before they would go to enforce it. And they were unable to get in touch with Mr. Taylor, and at that point told us that there was nothing, it couldn't go any further.
So no action was filed in the Superior Court?
Correct. No action was filed in the Superior Court.
Thank you.
Great. Please proceed. Sorry, I think you said that was it for Mr. Zumwalt.
Yeah, I have no more questions for the witness.
Colleagues or commissioners, any questions for Mr. Zumwalt? Seeing none, thank you. You didn't have as far to travel as the other witness, but thank you.
I have nothing further except my closing statement.
I think that makes sense. I'll just I was going to read just some of the rules that govern our process here. And I think we can discuss again the mechanics of how we go forward, but we can do that after the closing arguments. But I just wanted to read out the standard of proof. And this is from Rule 9A in the enforcement regulations, I believe. The commission may determine that a respondent has committed a violation of law only if a person of ordinary caution and prudence would conclude, based on a preponderance of the evidence, that the respondent has committed or caused the violation. So preponderance is our standard. So unless my colleagues have anything else they want to talk about, we can ask Mr. D'Amico to start with this closing statement, argument. Please go ahead.
Excuse me.
Mr. Clerk, I think it's 15 minutes again is the cap again. That doesn't mean you have to go that far, but that's your roof, not the basement.
Thank you for your patience. I know it can be fairly painstaking to go through slowly the recounting of the facts and the law, but I appreciate it. I want to take this opportunity to demonstrate how the evidence fits into the legal framework. Again, with the time limit, I would ask any questions saved for the end. First, I believe the Enforcement Division has demonstrated that Mr. Taylor worked with the JAL campaign producing advertisements, coordinating with a vendor to place billboards, submitting at least one ad to the Ethics Commission. Next, we've shown that Mr. Taylor coordinated between the candidate, a potential donor, and AFPAC to arrange for a $10,000 contribution to AFPAC for the purpose of supporting the JAL campaign. Third, we demonstrated that Mr. Taylor worked with Clear Channel to supply designs and locations for these ads identical to ones produced for the campaign. In doing so, we've shown in several ways that Mr. Taylor coordinated AFPAC's expenditure under law, turning it into a contribution. So first, if it's helpful, I do have Exhibit HH, which is just a copy of the coordination law, since it is sort of a complicated law, and I thought it might be helpful to have it projected for everyone.
Yeah.
Great. Mr. Wilson, could you please pull up Exhibit HH? This is just a copy pulled from the public website of Section 1.115 of the Campaign and Governmental Conduct Code. So I will start at the highlighted portion at the top, and the law states that an expenditure, this is subsection A, general. The law states that an expenditure is not considered independent and shall be treated as a contribution if the expenditure funds a communication that expressly advocates the nomination, election, or defeat of a clearly identified candidate and is made under one of any three different circumstances below. So in this case, the evidence has shown that AFPAC's expenditure funded a communication that was advertisements on billboards, and that communication clearly identified and supported the election of Ellen Lee Zhao for mayor. Before moving on to that specific subset of circumstances, just briefly, Investigator Wilson, if you could show the bottom highlighted portion. All the way down, subsection D, so for the purposes of this section, the term candidate includes an agent of the candidate. So every time this section says the word candidate, it includes an agent of the candidate. This is relevant because in this case, by producing advertisements, coordinating details of the campaign spending with a vendor, sending advertisements to the Ethics Commission, putting himself out to numerous parties as an agent of the campaign, such as Outfront Media, and consulting for the campaign, the respondent was acting as an agent of the candidate. Investigator Wilson, please move back to the top of subsection 1.115. So now I want to walk through the requirement that an expenditure be made under any one of three circumstances to be considered actual coordination under the law. The evidence has shown that the expenditure in this case was made under at least two separate of these circumstances. So first, the highlighted portion in A1, where an expenditure is considered coordinated if it is made at the request, suggestion, or direction of, or in cooperation, consultation, concert, or coordination with the candidate, including the candidate's agent, by definition. The evidence has shown that Mr. Taylor first reached out to the president of AFPAC. He connected him with the candidate and a donor. He brought a copy of an ad to a meeting with the president and the donor, and he arranged details with the vendor. In doing so, as an agent of the campaign, Mr. Taylor suggested the expenditure and proceeded to consult, coordinate, and cooperate in its execution. This meets that criteria and alone establishes that the expenditure was coordinated and should have been treated by law as a contribution. But the expenditure was made under an additional circumstance described in subsection A2A. The communication was created, produced, or disseminated after the candidate, again through her agent, made or participated in making any decision regarding the content or location of the communication. We've shown through evidence that Mr. Taylor selected billboard locations for AFPAC's expenditure and supplied art to the vendor Clear Channel. In doing so, he made decisions regarding the location and content of the communication. This provides separate and independent legal justification for a determination that it was coordinated. Under any one of these circumstances, the expenditure should have been treated as a contribution. Investigator Wilson, if you could maybe, we can already see subsection B. I'm going to discuss that next. So we believe the evidence shown is enough to conclude that the respondent coordinated AFPAC's $10,000 expenditure. Just in case, we would like to briefly describe additional legal provisions that would allow the commission to find that coordination occurred. Yes.
I'm sorry, I'm going to ask you a question. Mr. Clerk, is there a way to pause the clock so that we can ask questions during the presentation? I think that'll be more efficient. Mr. D'Amico, is that okay with you? For A1, we're talking about not rebuttable presumptions, basically irrebuttable presumptions.
Correct.
So I think for A1, the expenditure made at the request, suggestion, so on, the evidence for that is what? That Ms. Zhao is copied on the email?
This is that Mr. Taylor coordinated.
Right, but what's the evidence that was coordinated with the candidate?
Because
agent, is that?
Yeah, he's an agent. He's an agent and he coordinated with the PAC.
Right, but I'm looking at A1. So you can help me, maybe I'm misunderstanding it. The circumstance that describes this when the expenditures are made at the request, suggestion, so on, with the candidate.
Yes, and in this case, it was the candidate's agent, because the candidate's agent is included in the definition of candidate for this subsection alone.
Got it. And then to establish his agency, is that you're going to get to that later?
I can discuss it now if you'd like, or if we're still on pause.
We are paused, but I don't want to derail you, but at some point you'll address the agency.
I think I should just address it now. It's my notes are up there, but so there's the California law establishes. Could you grab me the notes right under the mic? Yeah. Thank you. So California law, that's fine, establishes something called ostensible agency. This exists when a principal fails to exercise ordinary care in clarifying that a person does not have the authority to act on the principal's behalf. I would first point out a couple of things. First of all, there's a case called Common Sense Voters. In that case, the respondent worked as a campaign consultant, and this commission deemed that that was sufficient to call that individual an agent of the campaign. Later in my closing statement, I discuss how Mr. Taylor qualified as a campaign consultant because selecting vendors and arranging for campaign advertisement and literature qualifies as campaign strategy and leadership, and if you're paid over $1,000 for that, you're a consultant. I will get to that, but by qualifying as a consultant, this commission deemed that was enough to call someone an agent. Separately, in the case Lloyd Johnson for West Covina City Council, John Shoemaker was deemed by an administrative law judge to have acted as an agent for the candidate Lloyd Johnson. What Mr. Shoemaker did was he arranged for a transaction between the campaign and a vendor for campaign materials, and then when working with a similar vendor he was considered an agent on working on similar campaign materials. Those were flyers and leaflets and brochures, but when working on similar materials, his agency carried over. Again, in this case, he arranged the transaction for similar or identical billboards with Outfront Media, and he picked locations with Outfront Media. That made him an agent, and then in the course of that agency, while working on similar or identical advertisements with a vendor, this is with AFAC now, his agency carried over, and he was operating in the course of his agency. Further, the fact that he copied Ms. Zhao on multiple emails shows not only that he was an agent, but that his work with AFAC was in the course of his agency. Meeting with Ms. Zhao before the meeting with the donor, again, shows that he was acting in the course of his agency.
Thank you. I was going to say the same thing.
Just so that I can refer to
Oh, Exhibit HH?
Yes.
Yes.
Please.
Mr. Wilson, could you put that back up, please?
I'd just like to consider an interpretation of the rule, and I'm wondering your thoughts once I read it.
Yeah.
Yeah.
Mr. Wilson, could you please put up Exhibit HH? Can also provide, I believe it should be in your physical packet.
Oh, that's true.
It's the last page.
Yeah, it's just a single page.
Okay. Okay. So this, I'm reading A1, the expenditure is made at the request, et cetera, the candidate on whose behalf or for whose benefit the expenditure is made. If we're considering, if we're reading candidate as agent, are we then considering Paul Taylor's benefit from the expenditure made? What would you say how would you respond to that interpretation? Because I understand the connection you're trying to make of, if we read this as he was the agent and then.
I read it as the candidate's benefit, since it's not just him personally, but him as an agent. And in his agency, he's representing the candidate. So I would read the benefit as to the candidate through her agent.
Okay.
I have another question. Can a friend be an agent in those cases that you saw? Were any of those people considered friends?
No, the court didn't discuss that personal relationship had a bearing on it, or the commission or the administrative law judge, excuse me.
And all of 115A relies on agency, right? All of your arguments as to those.
As to those, yes.
As to the irrebuttable presumptions.
Yes.
For example, you're not asserting that the expenditure itself was made with the candidate's actual coordination, participation, et cetera.
Well, in this case, this entire case is against Paul Taylor for causing the violations. And at this point, we can't necessarily speak to potential ongoing investigations into it, but that would have to be an enforcement matter against the candidate or her. And this is just against Paul Taylor. So yes, it does. Those two that I presented so far do rest on agency.
Right. Thank you for letting me cut in there.
Of course.
Unless we have other questions on that section, we can proceed with your presentation.
Great. I'll resume.
One second.
Oh, sorry.
Just a quick, I think, to clarify on the causation standard, that's what you're citing, San Francisco Charter C3.699.
Yes.
And that.
Yes, that should be in the hearing brief.
Yeah.
Yes.
And that includes who causes any other person to violate any such provision or who aids and abets any other person in such.
Yes. Yeah. Okay. Are we all set to start the clock?
Go ahead. Yeah, thank you.
Okay. That was good timing. Hopefully you have Exhibit HH in front of you. I'm going to look now to the rebuttable presumptions. So for cases where there may not be enough evidence to show actual coordination, the law includes a set of circumstances that trigger a rebuttable presumption of coordination. If an expenditure is made under any of these circumstances, there is a legal presumption of coordination, and the burden shifts to the respondent to show that there was no coordination or that he did not cause it in this case. Highlighted is subsection B, which provides 5 different circumstances that trigger a rebuttable presumption of coordination. We believe the evidence has shown that the expenditure in this case was made under multiple, at least 2. We're going to focus on 2. First, highlighted is B2. I think this will be fairly obvious given our previous discussion, but this states that an expenditure made by or through any agent of the candidate in the course of the agent's involvement in the current campaign. And again, I'll just reiterate what I went over before, but the evidence has shown that Mr. Taylor was involved in the ads purchased by AFPAC from start to finish, and the expenditure was made by or through him when he called Mr. Tsuneshi, arranged a donor, supplied designs, coordinated with the vendor. They also show that he did this during the same time period that he coordinated similar advertisements on behalf of the Zhao campaign with Outfront Media. The dates for the advertisements were the exact same, and the advertisements themselves carried similar, the billboards themselves carried similar ads. And that when communicating with Clear Channel and AFPAC, he copied the candidate's email address on several emails. This shows that, again, not just was Mr. Taylor an agent of the campaign, but the expenditure by AFPAC was made in the course of his involvement with Ellen Lee Zhao's campaign, and in doing so triggered a rebuttable presumption. Second and separately, I draw your attention to subsection B4. If an expenditure funds a communication that replicates, reproduces, republishes, or disseminates, in whole or in substantial part, a communication designed, produced, paid for, or distributed by the candidate, there is a rebuttable presumption that the expenditure was coordinated. The evidence has shown that all 5 advertisements paid for by AFPAC were substantially similar in whole and in part to advertisements paid for by the campaign. This includes one advertisement sent to the Ethics Commission by the respondent, Mr. Taylor. Mr. Tsuneshi also testified that he was not aware of these advertisements and that Mr. Taylor came up with the idea for the billboards. I will note, especially given the questions, that this rebuttable presumption does not require Paul Taylor to have been an agent of the candidate. Either of these criteria would be enough on their own to trigger that rebuttable presumption. As I led with, we also believe the evidence meets the standard of 2 separate definitions of actual coordination. The Commission need only agree that any of these circumstances were present to find either that a rebuttable presumption or a non-rebuttable presumption of coordination exists, and that the expenditure should have been treated as a contribution. We can take HH down now. Moving on, by coordinating this expenditure, Mr. Taylor turned it into a $10,000 contribution under the law. San Francisco and California law require certain things of contributions. San Francisco law limits contributions to $500. Because this was a $10,000 contribution, both AFPAC and the campaign violated this limitation. Second, city and state law require reporting of contributions on semi-annual statements. Again, neither AFPAC nor the campaign reported this $10,000 as a contribution on their semi-annual statements, violating the law. Third, city and state law require reporting of large contributions made within 90 days of the election. Again, neither AFPAC nor the campaign reported this $10,000 contribution as a late contribution. Because Mr. Taylor's coordination created all of these legal obligations for AFPAC and the campaign, he caused the violations, and that is why he is the respondent in this case. These violations make up counts 1 through 6 in the Enforcement Division's hearing brief. We've also established that Mr. Taylor's work for the campaign qualified him as a consultant who is required to register with the Ethics Commission.
Mr. D'Amico, sorry, before you move, you're moving on to the next counts, is that right?
Yeah.
Can we ask some questions about these counts now?
Sure.
Pause the clock, maybe. Yeah, thank you. I'm specifically interested in the failure to disclose counts. So looking at count 3, which alleges that Mr. Taylor caused the Zhao campaign in Zhao to fail to disclose required information, and count 4, which alleges that he caused the PAC to fail to disclose required information, and count 5, which alleges that he caused the Zhao committee and Ms. Zhao to fail to report a late contribution, and count 6, which is the same allegation but as to the PAC.
Yes.
I understand the argument and the factual basis for why the commission alleges that he caused the expenditure to become a contribution and caused the committee to accept the contribution and the PAC to make the contribution. Don't Ms. Zhao and the Zhao committee and the PAC have an independent responsibility to disclose required information under these counts?
They have an obligation to report contributions, yes. And it is our claim that Mr. Taylor caused the violation because his coordination turned this from an expenditure to a contribution. So if he had not coordinated, both the campaign and AFPAC would have been in compliance with their reporting obligations. Because he coordinated it, it was no longer an independent expenditure, but a contribution. And therefore, they had different legal obligations that he brought about, and they did not comply with those legal obligations, so he caused that noncompliance. I would also note that the law makes them, they're jointly and severally liable for these, so this does not necessarily preclude their liability.
Understood. What did he do to cause those entities not to report as they were required to?
He created the obligation, and as you heard from testimony, Mr. Tsuneshi was not aware. Mr. Tsuneshi asked if he worked for the campaign. He looked on their website, and so he was not aware that he had to comply with those laws in the first place. He thought he was making an independent expenditure. So he did not. So by creating the obligation, he caused the violation. There's a case, the FPPC has a case, I believe it's referenced in the hearing brief. It's the Fury case. It was a very similar case. And in that case, there were 4 counts that are essentially identical here. The expenditures were around $35,000 that were made for the campaign and facilitated by a third party. The third party was the respondent, and 4 of the counts were for the late contribution form not being filed and the contributions being reported as expenditures instead of contributions. And they were because the person who created the legal obligations caused the violation.
So as to the PAC, and if we credit Mr. Tsuneshi's testimony that Mr. Taylor, he relied on Mr. Taylor's representations that there was no coordination there, it would seem like there's a clearer nexus as to why Mr. Taylor caused the failure to report. But let's presume hypothetically that it doesn't have to be about these facts, but you're in a situation where the entity that fails to report is actually aware that there's some skirting of the independent expenditure and contribution limits, and so they're presumably aware that they're supposed to be disclosing that information. Wouldn't you need to show that the person facing liability in some way was contributed to that decision not to disclose?
Not according to the commissions that have dealt with this before. By creating the violation, he is the one who by creating the obligation, he is the one who coordinated. There is a secondary question if this were a case against the campaign or Ms. Zhao of whether she knew or should have known what her agent was doing. But this is, since it's just focused on him, just by showing that he created the legal obligation, at least based on other cases and our interpretation of the law, that means that he caused the violations.
If we were to think that the causation showing has to be a little bit stronger for the failure to disclose arguments than just taking the steps to convert this from an independent expenditure to a contribution to begin with, are there facts here or evidence here that you've introduced from which we could infer that Mr. Taylor did anything to mislead Ms. Zhao or the Zhao committee into believing that this was not a contribution?
Other than essentially keeping them out of it for the most part, I mean, that is what we relied on, the fact that he specifically set up a meeting with a donor and did not have Ms. Zhao attend the meeting. I would also note that Ms. Lee, or Margaret Lee, the donor, she had donated the maximum amount to Ellen Lee Zhao's committee, her campaign committee, and could no longer donate anymore. And so they were aware that she could not contribute anymore. And so he then led her to Mr. Tsuneshi and didn't include Ms. Zhao on most of the communications, and coordinated both the advertisement with Outfront and the advertisement with Clear Channel on his own. So just the act of shielding from her the coordination that he was doing, he prevented her from becoming aware of her legal obligations.
But in some of the emails we saw, Ms. Zhao was CC'd into the correspondence with...
Yeah, she was on a couple of them.
And that was in connection with the expenditures by AFPAC in support of her campaign.
Yes.
Okay.
I'm glad you raised that issue because I had the same reaction to charges 3 through 6. Mr. Taylor was not the treasurer or secretary for either of those campaigns, so it seemed I was struggling with the same question that Commissioner Salahi raised. So I think that's a helpful discussion. But do you have more questions on that same point?
I think that's it. Yeah.
Great. Let's we'll turn the clock back on, and then you can proceed. Thanks, Mr. D'Amico.
Okay. So as I mentioned, we've established that Mr. Taylor's work for the campaign qualified him as a consultant. He produced, or by producing or authorizing the production of campaign literature, this is the definition under law of campaign strategy, services related to campaign strategy. By coordinating with Outfront Media to produce advertisements and turn them into billboards, he provided services related to campaign strategy. In doing so, he was paid over $1,000 based on the exhibits we have shown today, and therefore qualified as a campaign consultant. He also participated in selecting vendors, which consists of services related to campaign leadership, which is a second and separate service that would have qualified him for becoming a campaign consultant. He did not register as a campaign consultant and therefore violated city law. Finally, we've shown that Mr. Taylor repeatedly and willfully withheld evidence from the Ethics Commission, and in doing so failed to furnish, which is count 8 of the hearing brief. He failed to furnish relevant evidence and violated city laws that are designed to ensure smooth and efficient operation of Ethics Commission investigations. Our campaign finance laws are designed to help voters make decisions, informed decisions, and to prevent undue influence of elected officials. Campaign contribution limits are intended to ensure that no single person gives more than $500 and cannot wield outside influence on a single election. Campaign reporting violations deprive the public of essential information regarding political contributions, and when a lack of reporting conceals circumvention of contribution limits, as it did here, again, this is the reason for counts 3 through 6, is the failure to report this properly prevented the Ethics Commission or other regulators from finding out that there was a contribution far over the limit of $500. So when a lack of reporting conceals other circumvention of laws, that harm is magnified. In this case, respondent caused a $10,000 in-kind contribution to be made and accepted 20 times over the legal limit. This illegal contribution also allowed the campaign to purchase 16 billboards using the exact same advertisements it had produced and distributed all on its own, but it had only decided to spend money on 4 of those billboards that it could get through contributions. So they got 16 additional billboards, all while avoiding contribution limits and disclosure requirements. A coordination also allowed the campaign and AFPAC to align their goals but evade campaign finance rules. In the process, Mr. Taylor also deprived the public of information regarding his activity as a campaign consultant. Again, registering as a campaign consultant would have given the Ethics Commission the opportunity to see that there was potential coordination. Furthermore, respondent actively impeded the staff's investigation, ignoring emails and phone calls, failing to provide information in response to a subpoena, and sending letters demanding millions of dollars from staff members if the investigation was not suspended. We believe the evidence has met the standard of proof that a person of ordinary caution and prudence would conclude by a preponderance of the evidence that respondent violated the law on the 8 counts in the Enforcement Division's hearing brief. In light of this, we ask the Commission find violations on these 8 counts, 6 counts caused by respondent's coordination, 1 count for failing to register as a consultant, and 1 for withholding information from the Ethics Commission. The Enforcement Division seeks a total penalty of $15,950. That concludes my closing statement. So
we've just some logistics. We've gone at it for a while. I wonder whether folks want to take a short break, but I think at some point we need to have I hope, a robust discussion of what we've heard today. We should talk about how we want to proceed in terms of addressing the merits in the case. I'm just airing whether we want to do that right now or take a short break to attend to whatever we want to do.
I'm okay with taking a short break, but I'd like to ask a few questions about the closing before.
Let's do that now then, yeah.
Thank you. Just on count 8 on the withholding information, are individuals required to respond to informal requests for information?
they're not required, no.
So the only basis for that violation would be properly served administrative subpoena, failing to respond to properly served?
Yes, yes.
And is it your understanding that providing objections in response to an administrative subpoena would constitute a response to that subpoena?
Not if those objections don't come within the deadline for providing an objection.
So they have to be timely objections?
Yes.
Okay. Thank you.
Are my colleagues and staff, does maybe a 20-minute break, 15-minute break sound okay? I don't know if folks want to grab lunch or does a shorter break works for everyone. Also be respectful of staff who've been here for, well, as long as we have. 15 minutes sound okay?
That seems fine to me.
Great. 15 minutes. All right, we're back on item 7, discussion and possible action regarding hearing on the merits in the matter of Paul Allen Taylor. So I think we should talk about mechanics going forward and then substance. On the mechanics, I think we've absorbed a lot. We can either vote today on these charges, or I think we can have a robust discussion and then designate probably one of us to kind of draft up proposed findings, submit it so that it's on the agenda for next month, vote on whatever that is, informed by our discussion right now, including if we find violations, whatever penalties or other orders might attach. I think there are a couple of matters that we've discussed that I think we could even ask for additional briefing on some questions that I have, which would, I think, be helpful as opposed to trying to resolve it today. This is my hunch, but I'm curious to see what you all think.
I'm curious what you mean by additional briefing.
There are a couple of questions that I would like more information from staff, or frankly from Mr. Taylor. He didn't participate in the evidentiary portion, but I welcome it from him as well, regarding the causation issues for charges 3 through 6, the causing violations. I'm just not sure that I'm there yet that his role satisfied the causation liability. I just don't know. And if I had to vote on it right now, I just don't feel like I have enough of a understanding of that particular issue. I'm also, yeah, so that's, well, frankly, that's the main one that I think additional, probably legal briefing would be helpful. But I'll open up to you all for your thoughts.
Yeah, I just wonder if actually it would be helpful. I mean, as I walked out, I saw that Mr. Taylor is in the building, and I wonder if, prompting him or inviting him back in, urging him and letting him know that the resolution would be, facilitated by his presence could help us here.
Well, I don't know, we can't take evidence from him. That part's over. So I'm not sure. How do you think his appearance would?
Well, to the extent that there are, I mean, I guess it sounds like you're interested in more legal briefing, but I didn't know if for the causation argument you were also interested in more factual evidence, but.
Well, I am. I wish he'd participated, but he didn't, so I don't think we can cross that bridge now.
Yeah.
So I think purely a legal matter, I'm interested in that issue.
Is the effect of requesting supplemental briefing postpone when the 45-day period begins to run?
I don't think so, but I'd welcome our Madam Deputy City Attorney to weigh in, because that's not my intention at all. My intention is to maintain the deadlines, but to the extent we can, get additional help, sorry, not additional help, additional legal research where helpful.
Hold on, let me just take a look at the rule.
And if it does, then I would forego that request and stick to the deadlines. But aside from that, just the concept of us having a robust discussion today, having one of us draft up a tentative or proposed findings and then addressing it at the next meeting, how does that sound to folks, as opposed to doing it all today?
I'm okay with that as well. I would prefer that, actually. Yeah.
Yeah, I think we've taken in a fair amount of information, and I think we could benefit by having the time to consider it.
One question that I have on the logistics of reviewing whatever the proposed order is and voting on it, if there are disagreements as to specific counts or specific legal or factual findings amongst the commission, how does that get manifested at the next hearing? Do we submit different?
Yeah, that's a great question. My understanding is that we could amend whatever the proposed findings are live, informed by our discussion, and then we would vote on each separate allegation. So I don't think commissioners would submit kind of dissenting views. I think we would work off the live document in essence. But if any of that doesn't make sense, then I would welcome the Deputy City Attorney to correct me.
I'm sorry, I was reading the other rule. Can you repeat that question?
Sure. So I think, do you want to ask Commissioner Salahi?
Sure. The question is, when we have a proposed tentative order or whatever we're calling it for the next hearing for consideration by the commission, to the extent that there is not unanimity on any particular count or legal question or factual question, how would that get reflected in our proceedings? Would we have a separate vote per count, and if anyone wants to say anything on a particular count or point, they would do so in connection with each vote, or is there another mechanism that we need to follow?
So you could do it, if I'm understanding your question correctly, you could vote on each count, or you could vote on all the counts together. And was that your question? And there would nothing would prevent you from having a discussion during that process of deliberations. Is that your?
I think that's right, and we're not required to submit separate writings from commissioners who might have a different view on anything.
Well, for the body to submit for each order that the body makes, you need 3 votes. I'm not aware of anything that would prevent a commissioner who disagreed to write some kind of a dissenting opinion or finding. If that's your question, is that what you're asking?
I think I understand it now. We can break it down by count and
I'm sorry.
discuss it.
Yeah.
No, it's okay. No, that was perfect.
And then
Thank you.
in terms of your other question, it says, the rule says, if the commission conducts the hearing on the merits, the commission will determine no later than 45 calendar days after the date the hearing is concluded whether the respondent, has committed a violation of law. So my understanding is this is now the conclusion. You have now all the evidence is submitted, and this concludes the hearing on the merits. Is that correct?
That's right.
Then
So
I think that I think there's an argument that the 45 days will begin to run from the point at which you make the decision.
Not from today, but from when we vote on the charges? Is that what you're saying?
No, I think you're going to have to make a decision within 45 days of this date.
Right. And I think as part of the conversation, we're supposed to issue findings of fact and conclusions of law. I think the question there that Commissioner Salahi was getting at is, if one of us proposes findings of fact, conclusions of law, that we then discuss at the next agenda meeting, commission meeting, to the extent there's not unanimity on those findings and conclusions, can we edit that document live at the hearing itself so that we can still issue it? That's the kind of mechanical question.
Yes, you can do that.
I have a related question actually to the development of the proposed findings, because this is I think it's kind of a Brown Act question. Is it going to have to fall on one person to develop that document? And then the rest of the commission needs to wait until it's on the agenda to review and the meeting to discuss?
That's correct. Any commission work on the document would have to happen in an open public meeting. But one commissioner could prepare, or the staff could prepare, propose findings and order and submit it then at that meeting, where then you could all discuss it and you could edit it at that meeting. Or adopt it as drafted.
Okay.
That proposal would be posted before the next meeting, correct?
No, I think we have to vote on it at the same time to get within the 45-day deadline.
Right, but for example, like the staff, if staff, for example, were to propose, it would go on the agenda and would have to be posted the Friday before.
Oh, sorry, I misunderstood, yeah.
Yeah, okay. So the public would see it same time we would.
The public needs to see it close in time to when the commissioners see it, if that's the Brown Act rule.
Yeah, so it's a little awkward. We can't deliberate before the next meeting altogether. There's not going to be any separate conversations about the merits, so we'll be doing it live. But that's the process. So I think, does that make sense for folks? We'll proceed that way. We can ask staff, we can ask Mr. Taylor to prepare findings of fact, or one of us can do it ourselves, and then they'll be on the next agenda.
But we're also going to wait for your legal memorandum too, right?
Well, that's a separate question. I'm just curious for the Madam Deputy City Attorney, if we ask for briefing from the parties, does that somehow push out the deadlines? I think you're saying no if the hearing concluded today.
I'm just not sure. That's a question that I hadn't anticipated, and I just don't know the answer to off the top of my head. Whether what is in effect sort of post-hearing briefing on legal issues, whether that operates to reopen the hearing and thereby extend the deadline, I don't know. Something I can look into and get back to you right away, but I don't know off the top of my head.
Well, let me ask, do others of my colleagues think it would be helpful to get that briefing? Because if not, then I think Mr. D'Amico cited a couple of cases that we can look up on our own.
It might be helpful, but I'm concerned about losing 45 days and it not getting pushed out and then causing procedural problems with
No, I agree,
process. Yeah.
So maybe we forego that request. So then we should probably decide who's going to take the laboring oar on drafting the proposed findings or conclusions. Anyone interested? Any preference whether it's one of us or we ask the parties to do it? I think maybe easier to have one of us do it, so
we're happy to if you want.
I think we can have a discussion right now on the merits and then maybe revisit that question. So let's do that. Yeah. Anyone want to jump out with any reactions? I'm happy to share some thoughts, but I also want to yield to other folks. So just going backwards, count 8 is the, I guess, getting in the way of the process. I'm not sure I'm comfortable without a Superior Court. Basically, in civil discovery, you propound subpoenas all the time. Someone does not respond, that does not necessarily give rise to contempt. I think here, there's been a long history with staff and the respondent being non-responsive, but I think we're focused on just that subpoena. And I think I'm just not sure that without having the court actually weigh in, that I'm there yet on that particular charge. Nothing to do with the merits underlying the rest of the case, just purely on that charge 8, which has to do with the obstruction of the staff's process. I'd welcome a discussion on that. Pull up the brief.
I have a similar concern about that one. I don't know that it would require Superior Court intervention for us to find a finding here, but as I understand it, the administrative subpoena that we are concerned with is the one served on October 25th, 2022, and the respondent had to either produce documents in response to that within 25 days or objections within 20 days, which is 5 days before the compliance deadline. And there's some ambiguity as to whether or not, I think it's a legal ambiguity as to whether or not the objection deadline of, the compliance deadline of November 19th, which is 25 days from October 25th, November 19th is a Saturday. I'm not sure if that gets automatically pushed back to the following Monday, but if it is October 19th, 5 days prior to that would have been November 14th, and there were documents that could be construed as objections to the subpoena submitted by Mr. Taylor on November 16th. And if those are treated as an objection, it's not the same as compliance in the sense that documents were furnished, but he did something to serve objections. And in normal civil discovery, it would then be on, the onus would be on the propounding party to seek court relief to compel compliance. So I share that concern about not finding a violation here. That said, I do think that the evidence shows a clear pattern of evasiveness, non-cooperation, even dodging service, attempting to dodge service, and that's probably a factor that I would consider in assessing penalties under any other counts that are sustained.
Yeah, no, I think it's a really good point. I'll just point out we're dealing with a pro per party, so I think that is relevant to these to his conduct here. So my inclination, just sitting here right now, I agree with everything Commissioner Salahi said. That behavior goes to the penalties if we find violations elsewhere, but I would probably be inclined to not find on that count 8. Just, but welcome additional discussion.
Just to make sure I understand what you are intending when you say that it could be counted toward penalties, that you're not considering it a violation on its own? Sorry. I was just clarifying what Commissioner Finlev meant when he said that it could be considered for penalties, but that this count itself, he wasn't persuaded that we should find against Mr. Taylor.
That's a great question. So under the enforcement regs, there are a list of factors to consider when assessing penalties, and I think one of them is the degree to which the respondent cooperated with the investigation and demonstrated a willingness to remedy violations. So I think that behavior, to the extent that there are violations, would be appropriate to consider in connection there. That's what I meant by that.
For any of the
violations.
counts.
Right.
Okay, understood.
Any other, I'm sure staff would like to weigh in, but I think at this point we're just deliberating as the commission. So,
Chair, if I could, I just wonder if it might be useful to ask the city attorney's office to weigh in on section 1.170 and what is within the scope of failure to cooperate with an investigation, if it genuinely is limited only to non-cooperation with a duly issued subpoena, or if it would also include things as simple as ignoring staff investigator emails, ignoring phone calls, just not cooperating, because I think that's certainly how we understand that. That we do have the authority to investigate, which includes just talking to people, and if people don't provide us documents when we ask, that actually would be within this, that Superior Court's not our only mechanism.
Well, I welcome the Deputy City Attorney to weigh in if she likes, please.
Okay, I'm reading, just for everyone's benefit, the section we're referring to is Campaign and Government Conduct Code. I only know it by its abbreviation. Any person who knowingly or willfully furnishes false or fraudulent evidence, documents, or information to the Ethics Commission under this chapter, or misrepresents any material fact, or conceals any evidence, documents, or information, or fails to furnish to the Ethics Commission any records, documents, or other information required to be provided under this chapter shall be subject to the penalties provided in this section. So it's that which, so the informal requests I don't think would fall under that. The informal request that I understood the response to which was voluntary, but it would be the items to which he was required to respond. And I understand that to be the subpoena. Were there other, maybe you could ask if there were other things he was required to do that he didn't do.
I think that's what I'm getting at is
Yeah.
what is the scope of what someone is required to do? Is the subpoena the only thing they're required to do, or are they required to cooperate in any other way with an investigation? Because I think that's a pretty core part of our investigative authority as a commission.
I mean, it would be up to the commissioners, obviously, to ask the questions, but my understanding is what was presented is an item that he was required to respond to was the administrative subpoena.
Thank you. That's helpful. On item 8, on charge 8, any other comments from our colleagues? No. So we can go to items, kind of the core of this, on coordination. My understanding is that even if we don't find agency under subsection, one of the subsection dealing with duplication of the official or the candidate's advertising, that creates a rebuttable presumption of coordination. Here, I think it seemed uncontested that the ads were in fact basically duplicates of the official of the campaign's posters. And since we did not have any participation from Mr. Taylor in the evidentiary portion, that presumption I think is not rebutted. It stands as a rebuttable presumption that was not rebutted. I'm not sure I'm there on the agency, but I don't think we have to because that prong alone, as I understand it, is enough to create coordination, which will then inform the rest of the charges. But I'm curious to hear if folks have thoughts on the agency and the coordination. I think on the agency point, what I'm struggling with is we have sounds like a pretty informal campaign, lay actors, their friends and acquaintances, which just makes it tricky. But there may very well have been agency, but I'm not sure we have to get into that question if we find coordination under that rebuttable presumption governing identical or substantially identical posters, communications, or advertising, which I think there is. So I think that gets us to the coordination without having to address the agency question. Curious what other folks think. And that coordination, of course, will inform counts 1 through 6. Basically everything that remains. I don't know if it relates to the campaign consultant too, but that's how I'm thinking about the coordination issue. Again, there probably is agency, maybe there is, but I don't think we need to reach that because we have that other prong.
Don't we need to address agency to find that this prohibition applies to Mr. Taylor? Because it otherwise only applies to the candidate and the entities engaging in the expenditure.
Pull up that section. You're looking at 115?
Yeah.
So the portion I was talking about was B4, communication replicates, reproduces, etc. As I read it, there's no agency here at all. It's just if the correspondence by the if the communications by the would-be coordinator replicates the campaign's communications, then you have coordination, irrespective of any agency concerns.
I think it's in addition to subsection A, which is what Commissioner Salahi might be referring to, where we have to get through the agency in order to get to the rebuttable presumption.
So I think those are disjunctive. I think you can have A or B. Right, so under A, you have a bunch of irrebuttable presumptions. B stands alone and creates rebuttable presumptions. These are tongue twisters. So I think, as I read it, B4 standing alone creates coordination if that presumption is not rebutted.
But then the question is coordination between whom? And why is Mr. Taylor involved? Why is Mr. Taylor liable for it?
Well, I think, so there the facts are that he's the one who basically duplicated the campaign's the campaign's communications and had them disseminated.
But if, let me think about that.
Yeah, these are interesting, thorny legal issues, which is another reason I think why having more time to deliberate on this makes sense. But that's how I'm analyzing this.
No, I agree with that observation. I think we do not need agency for B4, and that it is a presumption here, right? So it's a rebuttable presumption, and I think it does not implicate any agency or requirement of it being a candidate's agent. That is.
Yeah, I mean, I can see a universe where you have a duplication, but then there's testimony or evidence that rebuts that presumption. You know, you can imagine what that would be, but we didn't have that here. So I think that rebuttable presumption stands.
But do we also want to decide on agency as well, just so that it is clear that we have it because Mr. Taylor wasn't here today, that we have it even under the non-rebuttable section A?
Yeah, no, that's a good point. How are you kind of analyzing that?
I think given that, it was a $10,000 spend with a well-known company to create billboards, no one else but an agent of the candidate would have done that act.
Right, I mean, certainly you've got him introducing the PAC to the candidate. You've got him copying the candidate on communications to the Clear channel.
So, sorry to belabor this, but B says there shall be a presumption that an expenditure funding a communication, et cetera. He's not alleged to have made the expenditure. He's alleged to have facilitated it on behalf of the campaign.
But I think that creates the presumption of coordination. You're saying what's his role in that?
Right, because he's not directly, the coordination in and of itself is not one of the counts that he's alleged to violate. Everything kind of flows from that.
I think as a factual matter, well, first of all, we can ask Madam Deputy City Attorney, is there any objection to us asking staff for their opinion on these questions? And if Mr. Taylor were here, we'd ask him too, but he's not.
So you're saying, would you then be reintroducing new evidence? You're reopening that portion of the proceeding? Yeah, I don't think anything prevents you from reopening it.
No, sorry. Without reopening the proceeding, just asking them for their legal interpretation of these statutes.
I don't think there's an issue with that.
Mr. D'Amico, Mr. Ford, do you want to address that issue? The question is, B4, standing alone, does that create potentially?
Yeah, so I think I can get at your potential issue with it, Commissioner Salahi, and I think it's that it does create, my interpretation is that it does create a rebuttable presumption of coordination, but we would still have to show that the respondent caused the violation. And so you still have to show there is coordination, but why should he be liable for it? And I believe we made that argument in the course of it. But so yes, you don't need to show agency to show coordination, but now you need to show that he is somehow liable by causing that coordination.
So do we need to show agency to show the causation? Or you're saying we can show causation?
You can show causation without agency.
Thank you for clarifying that. Yeah.
Thank you. Yeah, that's how I read it as well, but that's really helpful. Thank you. I think we were discussing then Commissioner Sai's point about also finding agency. And I think those factors were introducing the candidate to the PAC, copying her on communications with it. Are there other kind of facts that you're thinking about? In terms of agency, I mean, I guess
he designed the ads, the first set of ads.
Right, never disclaimed any agency. So are folks comfortable finding, I guess there are kind of two alternative findings, agency, and to the extent there isn't any, there's also coordination under B4. So here we're talking about kind of the legal undergirdings for the actual violations, but I think the coordination and the agency are crucial for everything that flows after it. But it sounds like no one's held to this, of course, so this is part of a discussion. It sounds like we're comfortable that there was coordination under the presumption and the irrebuttable presumption. And then applying that to the actual charges. 1 and 2 are pretty straightforward for me. These are the ones tethered to I'm going to pull it up so I don't say it wrong. The actual contributions. So count one is based on causing the committee, the ZOW committee, to accept a contribution over the PAC limit. I'm pretty comfortable there, given what we just discussed about coordination and agency. This seems like squarely within that that fact pattern. Anyone comments on that particular count? Doesn't look like it. Number two, I kind of see the same way. This is about causing the PAC to make a contribution that exceeded the legal limit. I see that the same way. I think if there's coordination, then this follows. It's not disputed that the PAC spent $10,000 supporting the candidate's candidacy. Anyone see that? Any other comments on that count too? So then 3 and 6 are the ones I'm struggling more with, and that's just because I'm stuck on the fact that the PAC and the candidate committee had their own treasurer, they had their own persons related. I just need to understand the causing liability better. I'd welcome thoughts on that. Madam Deputy City Attorney, I don't know if you're prepared to remind us on the causation standard, or if it's already in the brief. I think
at the cited code charter provision. SF charter.
Page is that on?
It's cited under the counts. It's not quoted, it's just cited there.
Oh, I see.
SF charter section C3.699-13, paragraph D. Have that spelled out. Try to pull that up.
Thank you.
Would you like me to read that?
That'd be great. Yeah, thanks.
That subparagraph says, in addition to any other penalty that may be imposed by law, any person who violates any provision of this charter or of a city ordinance relating to campaign finance, lobbying, conflicts of interest, or governmental ethics, or who causes any other person to violate any such provision, or who aids and abets any other person in such violation, shall be liable under the provisions of this section.
So it sounds like it doesn't help us figure out what causation requires. I take Mr. D'Amico's point that he created the obligation. He certainly did. But to me, this seems different from 1 and 2, which are also kind of tethered to causing the violation. I'd also note that the facts are the same for 1 and 2 as for all the other ones. So in some sense, it's creating additional charges based on the same conduct. But I'm just not. I'm happy to ask Mr. D'Amico if you have kind of legal authority for what the causation liability kind of standard is, and maybe there isn't one.
So the best authority on the matter was this commission and how it interpreted that part of the law in the case Common Sense Voters. I will just read a paragraph directly from it, so I'm not editorializing. This first, I'll describe it, which this was a case where a campaign consultant for a committee coordinated with I believe it was with a general committee to spend money on mass mailers for the candidate. And by coordinating, he turned that committee into a controlled committee, which meant it had different disclaimers. And so the paragraph reads, respondent Common Sense Voters, that's the committee, failed to use proper sender identification on mass mailers sent in support of Mark Farrell for District 2 Supervisor. Respondent Chris Lee caused this violation through his role of campaign consultant for the Farrell Committee and his coordination with respondent Common Sense Voter. And then counts 1 through many were against respondent, the individual who coordinated for causing the violation. And the violation was that they didn't include the proper disclaimers that were required by a controlled committee, which his coordination turned the committee into a control committee. And they didn't disclaim that they were a controlled committee on their mass mailers. And so he caused those violations.
Did that case involve failure to make reports to the Ethics Commission or other authority?
It was 4 failures to disclose and then also a failure to file one form with the Ethics Commission. Yes. To amend a statement of organization, to clarify.
Mr. Amico, thank you. And I'm sure you did already, but can you just read the site for that into the record?
The site for that? Yeah.
If you have the case site.
Yeah, so this is Common Sense Voters, SF 2010. It's the matter of Common Sense Voters, SF 2010. Vote for Mark Farrell for District 2 Supervisor and Chris Lee. FPPC number 10/973. There was joint jurisdiction in that case, so both the Ethics Commission and the FPPC.
And it was cited in the brief, so I think Mr. Taylor had fair notice of it.
Yes, it was cited in the brief.
Is there anything, Deputy City Attorney, that precludes us from asking that opinion be added to the record in some way or shared with the Commission?
Are you saying that, I'm sorry, I'm having trouble hearing.
I'm sorry. Is there anything that precludes us from asking that the full opinion in the cited matter be shared with the Commission?
No, I don't think anything prevents that.
So to me, those counts 3 and 6 really stand or fall together. It's the same issue that binds them. It's that causation question. There may be one where we kind of put a pin on it and then we pick it up when we convene in a month after whoever's taking the laboring oar can put a draft together. But I'm curious to hear if folks have thoughts right now.
I had similar misgivings about counts 3 to 6, or at least questions about them. I think I'm not necessarily committed to this, but I wonder if the counts regarding the Zhao committee and Ms. Zhao are distinguishable from the counts regarding the PAC, given Mr. Sanushi's testimony earlier today that Mr. Taylor made representations to Mr. Sanushi, which he relied upon, that there was actually no coordination with the campaign.
Yeah, I think that's a really good point. It's kind of more of an overt act that caused that disclosure failure.
Mm-hmm.
I think that's a good point, yeah. Because I think for the other ones, we don't have any evidence of those kinds of overt acts. I mean, we have her being copied on emails, but not the same kind of affirmative misrepresentation, potentially.
And even if there were such a claim, I'm not sure I would credit it or give it much weight, given the context. But
yeah, no, that's a good point. For anything else on these 3 through 6? Okay, so I guess it's the number 7. This is his failure to register as a campaign consultant. This seems to me, sorry. Too many documents in front of me. So I think he was clearly paid more than the threshold. I guess it's $1,000. So I don't have too many questions on this particular count, but my question is does this count require finding of agency? And I'll pose that to Mr. D'Amico. I don't think so, but I'm curious what his reaction is.
No, there are campaign consultants. Agency is not in the law for campaign consultant.
And does it matter whether a person is a consultant to the candidate campaign or to the PAC? Like, is a consultant a consultant, irrespective of whether it's to a... Well, I guess here you're alleging that he was a consultant.
Here we are alleging it was to the candidate campaign, yes.
Got it. So that one seems pretty, well, I shouldn't say straightforward, but I don't see any contested evidence that would support finding that there was not a violation here. The facts being, I guess, he was paid above the threshold and he participated in selecting, recommending the vendor, and producing the production of the literature in her support. Any comments on this one?
I think that is the most straightforward one of the rest. Simply because it doesn't require agency. It seems pretty clear.
So I think those are kind of at a high level, helpful discussion. We could talk about, so the way just to summarize, I'm personally pretty comfortable on counts 1 and 2 based on just causing the excess contributions. Count 7 is the one we just discussed about campaign consultant. 3 through 6, I'm still working through the causation issues, so I'm going to put a pin on those for me personally. And then 8 is the one that deals with obstruction of the staff's process or the commission's process. They're even being mindful of what the deputy city attorney told us. I'm still not sure that I'm there on that particular count. So that's how I'm thinking about this at the moment. Just to summarize, are we kind of on the same page here? Again, we're not binding anyone to this. We're not voting right now, although we can if folks prefer, but that's how I'm thinking about it right now. And I think this exercise is helpful so that whoever's drafting the proposed findings will start out as close as we can get to the same page. In terms of any potential penalties, we can discuss that now, or we can discuss that at the next meeting when we've got actual proposed findings. I'll just say at the outset that I don't think the staff asked for 15,000. That is not where I would end up, given how I'm thinking about the counts. And I note that the biggest amount was proposed for count 8, $5,000, which would obviously be impacted by if we don't find a violation of count 8, although some of that conduct might inform the penalty as to the other counts. But I would welcome any comments on potential penalty considerations, just so we can have that part of the discussion as well.
Yeah, I have a question with respect to the penalties. Are there ranges, or are what is being sought here by the enforcement department the maximum amount?
It's just the recommended amount,
But I guess the question is, are we limited to certain kind of 1, 2, 3, or 4, or can it be any number between 0 and?
So there maybe you are better suited to
5,000,
answer.
I believe.
Yeah, it's 5,000 per violation,
Up to
or
5,000, yeah.
or 3 times the amount of money at issue, and I can. So
This is not section 3.242 on penalties, right? That you're referring to, that you're getting this number from?
no, this is from, I believe, the charter, the city charter, yeah, where it's a maximum of up to 5,000 per violation, or alternatively 3 times the amount of money at issue.
I think the short answer is anywhere from 0 to a lot is our discretion here.
30,000, I think, right?
Well, I think
30,000 per count.
Yeah, I think it's triple, right, the amount at issue per count.
Wow, okay.
Which would be hundreds of thousands of dollars. Well, quick math, but.
And in assessing penalties, we are not bound by staff's recommendation as an upper limit per count or in total, correct?
That's my understanding. We're not bound or limited at all.
Okay.
And I think the penalty factors are laid out in the enforcement regulations, but I'm happy to just read them into the record if that's helpful. The commission will consider all the relevant circumstances surrounding the case, including but not limited to the severity of the violation, the presence or absence of any intention to conceal, deceive, or mislead, whether the violation was willful, whether the violation was an isolated incident or part of a pattern, whether the respondent has a prior record of violations of law, the degree to which the respondent cooperated with the investigation and demonstrated a willingness to remedy any violations, and the respondent's ability to pay will be considered a mitigating factor if the respondent provides documentation to the Director of Enforcement of such inability, which must include 3 years of income tax returns and 6 months' worth of bank records or accounting statements at a minimum. So I take from that those are suggested factors, but we're not limited to those, and that we can consider whatever we think is relevant. So I think if folks want to talk about specific numbers, we can, or we can save that until we are at a place where we're discussing the actual violations that we're finding.
Yeah, right, I agree, waiting on the numbers probably makes sense, but is there any discussion that we want to have as to the facts regarding each factor? Or is that
That's
better
a
saved for?
good, no, I think that's a good point. Do you want to share some thoughts?
Sure, I can do that. So just going through them, I think I agree with staff's view on the severity of the violation, at least the couple counts that it seems like we have some agreement on. I also think that factor 2, the presence of an intention to conceal, deceive, or mislead, looking at the facts here, it does strike me as a reasonable inference that this was a deliberate bypassing of the campaign finance laws, given that Ms. Liu maxed out at the $500 donation directly to the campaign first, and then her $10,000 donation to the PAC was solicited in further support of the Zhao campaign. So I would weigh factor 2 pretty heavily, because that's not good when people are violating our campaign laws intentionally. The other one that I think deserves heavy weight is the number 6, the degree to which the respondent cooperated with the investigation demonstrated a willingness to remedy violations. It seems like there was no indication of any good faith attempt to engage with the Commission's investigation here. And to the contrary, there was deliberate impediments put in place, non-cooperation with the hearing, unwillingness to testify, to produce responsive evidence, or to take corrective action in regard to the counts. So those are the 3 that stand out to me as being pretty heavy and might weigh in favor of penalties that are even higher than what the staff has recommended with respect to, assuming not all the counts are sustained, with respect to some of the counts that are sustained. But that's just my view.
Yeah, I think those are really good points. Any other discussion on the penalties? I think as a way forward, maybe I think we can designate one of us to do the proposed findings, but also ask staff and Mr. Taylor for proposed findings that we can work off.
It doesn't say.
That may or may
what it
not
could
be helpful, but throwing that out there.
I understood they were just deliberate.
Curious if we can take a 1 or 2 minute break so our colleague can join us.
That's fine. Yeah.
Let's just wait for 2 or 3 minutes, and then we'll reconvene or continue. Item 7, discussion and possible action regarding hearing on the merits of the matter of Paul Allen Taylor. We're just discussing a way forward. I think it makes sense for us to choose one of us to then take the laboring oar on drafting proposed findings and conclusions. I'm wondering whether we have any volunteers. If not, I'm happy to take the laboring oar, informed by the conversation we've had today. I would ask the staff if I'll wait and see if there's a reaction to that. No? I'm sorry, what? Are you missing a Commissioner Fuller-Sprang had to step out for a minute. You tell me what we need to do, whether we need to, I expect she'll be back any minute. Okay, I just want to just maybe state for the record, yeah, thank you, Madam Deputy City Attorney. The Commissioner Flores-Frank had to step out for a few minutes. She will rejoin us momentarily, I expect. Madam Deputy City Attorney, do we need to vote on designating one of us to draft the proposed findings, or can we just do that administratively?
I would recommend that you vote.
In that case, I think I probably need to wait for Commissioner Flores-Fang to come back, right?
I would recommend that.
Is there a way we can move on to other agenda items and then come back to this?
Yeah, you could do that.
I think there may be an item that does not require a vote. Item 8. Let me just ask staff, does item 8 require commission action? It does.
She's back.
Good. Not a problem. Commissioner Flores-Fang, we were discussing designating one of us to draft the proposed findings and conclusions. I asked for volunteers. Seeing none, I volunteered, but I'm happy to have you do it if you're interested.
Delegate to the vice chair, I'd love to.
All right, wonderful. So I think I move to designate, and I also suggested if it's helpful, we could ask staff for proposed findings. You could ask Mr. Taylor for proposed findings that you could work off or ignore
That would be
at
helpful.
your discretion.
That would be helpful, given the fact that you were present for this conversation.
So I move that we designate Commissioner Flores-Fang to draft proposed findings and conclusions for the next commission meeting. Any second?
Second.
Do we need to take public comment on this? I guess we do.
I don't think so. It doesn't hurt to, but I don't think you need to.
If we don't need to, then I think we'll skip it. Can you call the roll, Mr. Clerk?
On the motion for Commissioner Flores-Fang to draft the findings and conclusions, Vice Chair Fenlove,
Aye.
Commissioner Flores-Fang,
Aye.
Commissioner Salahi,
Aye.
Commissioner Sai,
Aye.
Commissioner Francois. Vice Chair, with 5 votes in the affirmative and 0 votes opposed, the motion is approved unanimously.
Thank you, Mr. Clerk. I think that concludes the presentation. Sorry, item number 7. I now call agenda item 8. Presentation, public hearing, possible action on Ethics Commission budget proposal for fiscal year 2024-25 and fiscal year 2025-26. Just as you're setting up, I want to thank the staff, and I want to thank Mr. Taylor's friends for being here for a long and productive hearing. Thank you.
I have a presentation I'm going to load up here, so just bear with me for a moment.
Stay until Anna gets back up. She's on her way back up.
I'm sorry, I didn't hear that part.
I'll stay until Anna gets back up, but I know she's on her way back up.
Would you prefer if Mr. Ford waited, or can you go ahead and proceed?
No, you can proceed. I just want to let you know I'm here if you need help, but
Got
she's
it.
coming.
Thank you.
I don't.
Okay, I'll get started then. Begin for the record, Executive Director Patrick Ford. I will make this as quick as we can with still getting through it. It is pretty important, but I do recognize how late in the day it is, and so I'll try and balance that. Just for context, again, we are required to have 2 public hearings on our budget before we submit it. The submission is due February 21st. This is the second and final public hearing on the budget, and we do need the commission to endorse the budget proposal before we submit it. So that's why this is agendized as an action item. Okay, it looks like the slides are up. So first I want to just briefly talk about strategic budget priorities for this budget. It is a 2 fiscal year budget. Even though this process happens every year, it is for a 2-year budget. So one of the things that we always look at, but especially right now, is to strengthen organizational capacity and effectiveness. And in particular, we're looking at divisions right now where we have new staff or where they're entirely new programs. So our engagement and compliance division right now is largely new staff. It's a very core part of our office's work. They run all of the disclosure forms. They help people who call in with questions. They're, in a big way, our public face, and most of those staff are new. They're doing a great job, but we really, really want to support that division because they kind of tie into everything else that we do. Also, our training division, Ethics at Work, that program area is largely new, so we really want to focus on continuing that work. In particular, we want to build an effective and sustainable audit program. We know that our outcomes from that division are not up to par right now. The candidate audits, which are required for every candidate that receives public financing, are not being completed until years after the election. We need that to be a lot faster. Also, we're no longer auditing other kinds of committees. So we don't audit ballot measure committees, we don't audit IE committees, general purpose committees, also known as PACs. We need to get back to doing that. You'll remember we've had some enforcement cases that came out of those kinds of audits. They're very important to do, but we are required by law to do the candidate committee audits. So we need to get those done first, then we can move on to those others, but both are very important to get back to. Also, I really want to see us deepen our engagement with other city agencies and with other regulated communities like campaign committees, lobbyists, other kind of people who are subject to our laws. I would really like to see our office engage more with other city agencies to help them think through how they can align their business processes with ethics rules. It's really something that needs to be ingrained into how the city does business. And these rules are something that not a lot of people know about. So we really want to form those relationships and kind of help people consult. We want to continue to improve our enforcement program. I think we've made great strides in the last several years, lots of new kinds of cases, new things like hearings. We want to continue that work. There's more to be done. So that's an area where we really want to continue to invest. And lastly, because we do have a negative budget outlook right now, is in a scenario where we do have to sustain cuts, that we want to do that in a way that minimizes the impact on the services we provide to the public. You probably saw some of this, or you did, last month, so I won't go through all of it, but this gives a snapshot of our current budget, which is the first column, and then the baseline budgets for the two succeeding years. And this is based on if no cuts were to happen. This is just our baseline budget. The numbers change a little bit, but not too much, and that's mostly based around cost of living adjustments. And you can see on the bottom that our budget right now is 87% salary. I know that's a little small, but that big blue bar at the bottom is salary. In the past, when we've been asked to cut our budget, we always try and cut from non-salary spending, which has resulted in a budget that is very, very salary heavy. Also, that's mostly just because of how we do our work. We don't have a lot of equipment. We don't have a lot of funds that we use to administer contracts or grants. We're really a staff heavy agency. So that's why you see that. At the end, very small portions for services of other departments like DHR, the controller, for really essential services, and then only 4% for non-personnel expenses like software licenses or laptops, that kind of stuff. It's only 4%. I do just want to mention that the election campaign fund usually does appear in the mayor's budget proposal as part of our departmental budget, but it is not part of our operating budget. Those funds are set aside for use for the public campaign financing program, which is where supervisors for mayor or candidates for supervisor or mayor can receive public funds to help fund their campaigns. Only a very small portion of those funds can be used for administrative purposes and only in connection with that program. So we do use that small portion sometimes to contract to have audits done, but it cannot support our operations in a general sense, only in that very narrow way. So it does go under our budget in the mayor's proposal, but it is not, strictly speaking, part of our operating budget. So I just want to draw that distinction. You'll know this already. This is more for the public's benefit, but this is a breakdown of our divisions. And this is our current org chart. And in this org chart, the blue boxes represent positions that are currently filled. The orange boxes represent positions that are currently vacant. And then there are two boxes that are gray. Those represent vacant positions that are slated to expire at the end of this fiscal year. So those positions will go away, and that's not actually considered a cut to our budget. They're just scheduled to automatically sunset. So the mayor's budget instructions, which I'll get to in a moment, require us to submit two different kinds of budget proposals. One of them represents a 10% cut to our budget. The other one represents a 15% cut to our budget. We have to do that, and we will, and I'll talk through those scenarios in a moment. But there's a third scenario which we will be submitting to the mayor's office, which is a zero cut scenario. Essentially, it would keep our budget flat, and I will describe why I think we need that and what we would do if we were able to get that funding. Then I'll go on and talk about if we do have to sustain the 10 and 15% cuts, how we propose doing that. So this slide talks about what we would do if we were able to achieve no cuts. First and foremost, to improve our audit outcomes, I would propose reclassifying the positions in the audit division, in particular reclassifying them to higher positions, both that have higher essential duties, knowledge, skills, and abilities, also that have a higher level of compensation. I think that one of the reasons that we have not had good outcomes in the audit division is structural, that the positions that we have, that we've been given by the city to do that work, are not at the level that we need to do the work in the way that we want it to be done, in the way that it's expected to be done by our office. So I would ask for those positions to be reclassified upwards. Similarly, I would ask to reclassify some, but not all, positions within the enforcement division. Right now we have kind of a new way of doing work on that division that I've talked to you about before, where instead of all investigators doing the exact kind of work, we've split up how the work is done. So some investigators do traditional investigative work, gathering evidence, interviewing witnesses. Other investigators act more like prosecutors. They take that information from the investigators, they write up hearing briefs or stipulations, they negotiate with the respondent's attorney, they bring hearings before the commission. There really is a distinction in those roles. So I want to actually formalize that within our agency's structure by reclassifying some of the positions. I also recognize that there is a real problem in our agency with bottleneck, that we only have 2 administrative positions overseeing all of the functions within the agency, the executive director position and the deputy director position. And I know from my own personal experience and from talking to staff over the last 2 weeks that there's an issue where work will get bottlenecked, where people are waiting to have their work reviewed, to get feedback, to get things signed off on, and there are just too many things going up at once. And also that those 2 positions, executive director and deputy director, are the only positions we have to deal with a whole slew of administrative issues like HR, procurement. There's just so many things that we have to do that are very labor intensive, reporting out to other offices, that it takes up a lot of time. And that, I think, is really hampering our ability to actually work with the division heads to talk about what kind of work they're doing, to help them plan. So that's something that I would like to try and address by adding 2 positions that would help with administrative work. And this is both administrative work that right now is getting absorbed by the executive director and deputy director. And there's also administrative work that is getting spread across other divisions that right now we just don't have a position to do. Some of these are kind of just routine tasks that don't have a home right now. So everybody kind of takes a piece of them. And I think overall that's kind of creating a drag in certain places. So I would propose having 2 positions that would help take on that work. I think it's critical also to fill the vacancy that we have right now on the engagement and compliance division. We actually have 2. We have 2 vacancies, but I think there's one in particular that is critical, which is the position that supports the Form 700 program. We are making that work right now. We are supporting it, but there is a position that was vacated last year that we still have not filled. And I think that that's a really key part of the services that we provide to the rest of the city. We have about 4,500 people that file the Form 700, and there's almost 500 that file it with our office in particular, and those are commissioners, department heads, elected officials. That position provides direct support to them. So when the leaders of the city contact our office to get help filing their Form 700, that's the position that they talk to. So I think it's really key to have that filled and to be providing really good service. And as I mentioned, this scenario would involve no cuts to our budget. It would involve other positions being held vacant in order to keep us flat, and that's represented in this proposed org chart. So again, the blue boxes represent positions that are filled already. The red ones would be kept vacant. The green ones would be filled. They're currently vacant and they would be filled. And then you can see with the arrow, some positions would be reclassified to a higher classification. So you can see below executive director and deputy director, those are the two administrative support positions that I would propose filling. Right now, the director of enforcement position is vacant. So I think that's a pretty important position to fill. Obviously, we have a great person acting in that role right now, but we do need to do recruitment to have a permanent candidate. Then you can see on the left, that's our engagement and compliance division, and the green box there is the Form 700 support position. The ones that would be left vacant are the clerk, engagement and compliance, the junior policy analyst, so we would keep just a one-person policy division, and then the junior investigator on the enforcement division, that we would leave those three vacant so that we could at least keep our budget flat and that we're not asking for an actual increase by keeping those three empty. So this table just breaks that down. So you can see in FY25, there would be no additional funding needed in order to achieve that org chart that I just showed you. There would be a very small funding need in the second fiscal year of this budget. In FY26, it would be only $77,000. So that's, I think, our ideal scenario, if we could get that. If we can't and we need to sustain some cuts, things would be a little bit different. So I'll recap really quick what the mayor's instructions were. So as I mentioned, number one is to submit a 10% cut scenario. Number two is a 15% cut scenario. So it's another 5 on top of the 10, 5% contingency. 3 is they don't want us to increase our headcount, number of FTEs. And number 4 is about maintaining our core services as much as possible, not decreasing the services that we provide to the public, even given a cut. Something that is not obvious when you think about a 10 and a 15% cut is that does not count our attrition savings target. So that is a separate kind of savings that we also have to achieve on top of the cuts. And this is true even in a scenario where we aren't having a cut, or even when our budget is being increased, we still have an attrition savings target, salary savings. So you can see that's the top line item, and that is in this first fiscal year of this budget, $644,000. Then on top of that, the 10% cut would be $680,000. So you have to add those together. So that creates a total funding gap in the 10% cut scenario of $1.3 million. And it's, I have the closed captions blocking this here. It's 1.6 million in the 15% cut scenario. So those are just the hard numbers of what these cuts represent. So as I mentioned earlier, most of these cuts would need to come from salary. We have very few places where we can save from non-salary. We have done that as much as possible. In particular, we identified a place where we could charge some of our NetFile contract, NetFile being the company that runs the electronic filing system that we use to carry out all of our electronic filings. So we could charge some of their work to a different fund rather than to our operating budget, our general operating budget. So we could save $59,000 if we do that. We've also discussed with the Department of Human Resources reducing our work order with their office. They think that they could still provide us the level of service that we're currently getting, but reducing it to 50% instead of one full FTE, which is what we currently have. That would save us $140,000. So we were able to find $200,000 only that we could save from non-salary. So everything else from that prior slide would have to come out of our salary budget. So these bullets represent how I propose we deal with a 10% cut scenario. First of all, I would still try to reclassify positions within audit and enforcement. I think that's really key to having those positions produce the kind of work that we need moving forward. But that the audit division would be reduced by one position. So instead of having 4 positions on that division, that we would have 3, but that they would be higher classifications with higher duty requirements and higher compensation. Secondly, I would still propose filling the 1844 Form 700 position on the Engagement and Compliance Division. I really consider that to be a key position in the office. But we would not be able to fill those 2 administrative support positions. We would not have the budget to do that. So we would have to basically continue to absorb that administrative work at the ED and DD level, and probably that's going to impact our ability to support the division heads and other people in the office. And this is what the org chart would look like in that scenario. So you can see the 1844 Form 700 position in engagement compliance is green, so that would be filled. And the Director of Enforcement position would be filled. Some positions would be reclassified upward.
Mr. Ford, I think
Yes.
this presentation is really helpful. I think you can go through the slides a little quicker because we can read them.
Will do. So in the 15% cut scenario, similarly, I would still want to increase the classification of the audit positions, but only have 2, and essentially roll those divisions together, enforcement and audits. The idea being that we would save on the amount that we're spending on management. So instead of having 2 separate division heads, we would only have 1 division head. So we would have a Director of Enforcement and audits, and have 2 auditors performing audits, which is still only a reduction from current in 1 auditor actually performing audits. Because although we have 4 positions on the audit division, that's 1 manager and 3 auditors. Only the 3 auditors actually conduct audits. So in this scenario, we'd be going from 3 auditors doing audits to 2 auditors doing audits, but at a higher classification and under the direction of the Director of Enforcement. I think we could also have a lot of savings there in terms of auditors being able to use existing procedures in the enforcement division, like the case management system, template documents, protocols. I think there's a lot of efficiency that we could find there. So that's why I propose doing it this way. We would not be able to hire the Form 700 support role in the first year of the budget. We would be able to do that in the second year of the budget. That has to do with, you'll remember back in an earlier slide, that our baseline increases, and that's just because of basically increases in cost of living and in how salaries go up over time. So we would not be able to fill it in FY25, but we would in the second year. And again, we would not be able to fill the 2 administrative positions. I'll skip the org chart. This recaps what I mentioned earlier about dates. So we have to submit our budget to the mayor's office February 21st. Between then and the 1st of June, there's essentially a negotiation process where we engage with our budget analyst, who's part of the mayor's budget office. We try and advocate for what our needs are and explain what the impacts of the cuts would be. And then on June 1st, or by June 1st, the mayor releases her budget book, her proposal. And then by August 1st, the board is the one that has to actually approve the budget. So there's kind of a second process, and you'll remember that from last year, that we engaged very heavily with the Board of Supervisors between the time that the mayor released her budget and the time that the board approved theirs, because we had a very, very serious budget cut proposed by the mayor's office. So it's kind of a 2-step process. You work with the mayor's office, and then if needed, you try to work with the board to change it. So that's the presentation, and yeah, glad to discuss it with you.
Any questions?
Yeah, just one quickly. Ms. Ford, you said at the beginning that you wanted to explain why you were also adding a 0 cut proposal, because the mayor's office hasn't asked for that, correct?
They have not asked for that.
Okay, so I just wanted to hear your.
That was purely my decision. I think we have done that in the past.
Okay.
That the ED chooses to do that. Yeah.
I had a quick question, and sorry if you covered this, but given the current vacancy for the engagement and compliance officer and the fact that the Form 700 deadline is coming up, do we have like support that's prepared to respond to any failure to file?
We do. We are making do. Kevin Kincaid in our office has really taken on a lot beyond what his work normally would be to help support that. Also, Anna DeCarolis in our office, who's on the Ethics at Work training team, she has been covering Form 700 work too. So we have people working out of their positions right now to cover works because we don't have that position filled, which obviously then is dragging those other teams down. So we're not where we would have wanted to be with our ethics training program because both Anna and Peter, who's the head of that team, have been doing engagement and compliance work for the last year.
Covering for one another.
Thank you, Mr. Ford. There's no action for the commission on this item, right?
I think we do have it agendized for action. I think we...
What I'm looking at says discussion, well, possible action. I'm not sure what the action would be.
Okay. I guess it's optional then. You could give me feedback. If you don't want to take action on it, you could at least give me feedback if you have any, and I could work with Gayatri to incorporate it.
I think we're happy to take action. I'm not sure what the action we're asked to take. Is it to basically endorse your priorities?
Yeah, that would be the idea, that when I'm negotiating with the mayor's office, that I could say that I have the support of the commission and that they share this vision.
Okay, in that event, I move that we support the staff's priorities as outlined in Director Ford's presentation.
I second that.
Then I think we take public comment on that item. Anyone in the room like to comment on this item specifically focused on the budget? Ma'am, please go ahead.
Well, good afternoon again. My name is Ellen, E-L-L-E-N, L-E-E-Z-H-O-U. In terms of response to the budget proposed for Ethics Commission, it's not about Ethics Commission alone. It's about San Francisco budgeted as a whole. Ethics Commission was established back in Proposition K that was passed by the voters in November 1993. For the last 30 years, without Ethics Commission or with Ethics Commission, the San Francisco residents or people has no benefit to it. Whether we have a San Francisco Ethics Commission or not, it's useless to the people who live in San Francisco. For the last 30 years, we see a lot of different news, a lot of different media about what's going on about Ethics Commission. I've been coming in here to report a lot of violations by selected candidates who are running for mayor or who are running for board of supervisor or in any other public positions. You all know there's only 18 electoral positions in San Francisco. But these people, they're all from one party. It's called the Democratic Party for the last 55 years. So Ethics Commission has not done a thing about stop corruption. It was established because of the corruption that we were facing 30 years ago. However, now we learn San Francisco has been operated by selected people into the office by the deep state cabal. It's called Agenda 21. It has been planned and plotted a long time ago to take down America. San Francisco is one of the test cities to do what it takes for a big city with small people. So think about it. San Francisco, we have less than 800,000 residents who live in San Francisco. However, our total budget for the entire city is $14.8 billion. That makes San Francisco the #1 wealthiest city in the entire global. However, San Francisco, it's famous for pool patrol, no plastic drinking stores, car break-in every day, defunding police, and the people in charge in Ethics Commission, they continue to do what is unethical. For example, I come in here and reported to you 1,168 unvaccinated people were wrongfully terminated in 2022, and they are godly people. So the San Francisco has been in darkness for a long time. So take note of this. Thank you.
Thank you. Mr. Clerk, will you check if there are any remote callers?
Vice Chair, there are no callers.
Thank you. That concludes public comment. Will you please call the roll on the motion to adopt staff's budget recommendations as outlined in agenda item number 8?
On the motion to support, on the motion to support staff's recommendation on agenda item number 8, Vice Chair Finlev?
Aye.
Commissioner Flores-Fang? Aye. Commissioner Salahi?
Aye.
Commissioner Sai?
Aye.
Commissioner Francois?
Aye.
Vice Chair, with 5 votes in the affirmative and 0 votes opposed, the motion is approved unanimously.
Thank you, Mr. Clerk. Item number 8 is now closed. Item number 9 is discussion and possible action on items for future meetings. Does any commissioner wish to speak on this item? Seeing none.
Yes, public comment.
Madam, Ms. Flores, we do need to take public comment, right? Even though there's no action. Ma'am, please go ahead.
Good afternoon again. My name is Ellen, E-L-L-E-N, L-E-E-Z-H-O-U. 2019, my campaign billboard was about human trafficking, homeless problems in San Francisco. But the deep state selected officials and some city leaders had 2 press conferences, told the voters not to vote for me and called me racist. I was told to go back to China. I was told to have I have no place in San Francisco City Hall, and tell me to get out of their face. And these people are selected into the office, and they're still in office. My billboard that I paid for by myself, now I don't know about whatever pact that you talked about earlier, we have many posters and billboards were illegally removed because of the 2 interference press conference by the selected leaders and electoral officials or selected officials. 4 days. In only 4 days, many of my posters and campaign billboards were illegally removed. And you keep talking about Ethics Commission. You're talking about how you can help the people to be better. How could it be better as a candidate like me? I worked for the city for almost 20 years, and I care about my city. I am a resident in here. I am a worker in here for the last 38 years. I have been treated differently because I support President Donald Trump. Because I am a Christian, and because I am a female Chinese immigrant, and because I am against corruption, and I spoke the truth to you. I am here to let you know I am not homophobic, I am not xenophobic, I am not transphobic, I am not racist, I'm not prejudiced or sexist. I don't care who you date or marry or have sex with. I don't hunt you down and scream and yell at you while you're eating in dinner. I will not talk to you to the street or anybody and causing riots, burn places or ground or root the store or any belongings. I will not force you my belief onto you and confront you to anything that you don't like. I want everyone to live their life or her life, his life, or whatever the life that they like. I will not tell you and what car to drive and what appliance to use and how to heat your home. I am a Chinese American, and I am for you and everyone in here. So today, I want all of you San Francisco commissioners, if you have future meetings and God protected your wealth and health, and if you are able to wake up for the next one, the next meeting, by God's grace, wake up, protect our city from the Agenda 2030, who are willfully trying to destroy San Francisco. I am here to stand in the gap for you and for San Francisco, and God bless you all. So do something productive to protect our city.
Thank you, Speaker.
Thank God for you.
Mr. Clerk, can you check if there are any remote callers?
Vice Chair, we're checking to see if there are callers in the queue. Vice Chair, there are no callers.
Thank you. Our last item is an additional opportunity for general public comment. Would anyone like to make public comment? Yes.
Good afternoon again. I am grateful for all of you that you're serving as commissioners. And I know many of you may not get paid and you just volunteer and get a stipend, but you have people who work for Ethics Commission as a staff. I worked for the CTR for almost 20 years, along with 1,168 Christians and Catholics file COVID-19 exemption. And after we filed the exemption, each one of us wrongfully terminated. And I'm publicly acknowledge it to you. I represent the government employee. I do not give up my freedom. I came from another country for freedom, and you today have the freedom that you exercise, and it's so sad to see each one of you that you're not willing to protect your freedom. Think about it. For people who are unvaccinated in the city government, they all get terminated. You know, people had bills, people had children, people had mortgage. What are you going to do when you don't have a job? What are you going to do? And you have people sitting in here, so-called Ethics Commission, but you're not willing to work with the civil services. You're not willing to work with the Labor Department or Human Resources or the mayor's office. And you continue to sit here and talk about non-discrimination policies. I am just sad to see such a groups. You are just one of those groups. We have more than 80 commissions in the city. Police commission, fire commission, ethics commission, civil commission, health commission, I'm just naming a few. But none of you willing to step up and look upon what I'm telling you. I am one of the 1,168 unvaccinated government workers refuse to bow down to the lie that COVID-19 was planned to take down America. And they use San Francisco as a test city and see how well that the shippers complied. How do I know? I work for the public health. I read data. I provide treatments to patients. And now we have more than 10,000 attorneys, more than 10,000 medical doctors came out and said this COVID-19 virus was never isolated. It was a host that people of propaganda colluded by the government selected leaders with the mockingbird medias keep lying, telling you to go test. But there's nobody get a COVID other than a flu and cold and a bioweapon that causing people get sick. I'm asking you, if you continue to have these ethics commission meetings, work with the people, reinstate all wrongfully terminated people in San Francisco, then it proves me that you are a human being.
Mr. Clerk, do we have any callers in the queue?
Vice Chair, we're checking to see if there are callers in the queue. Vice Chair, there are no callers.
Thank you. This concludes the February 9th, 2024 meeting of the San Francisco Ethics Commission. Thank you.